May it please your lordship. Your
Yes.
lordship, I beg to mention item number 22 of the daily list in motion column as senior counsel Mr. J.N. Satawala is out of session.
21,
Your lordship, on 20 March,
20th of March. Okay.
your lordship, a similar prayer on in item number 37 of the daily list in motion column.
37 NHM. You're with. Okay. On a prayer made on behalf of Sri G.N. Sahewala, Learned Senior Counsel, matter is adjourned to be listed on 20th 20 March. Item number, this is item number
22 and 37.
37. Okay.
Much obliged.
Where please, sir? I take to mention for listing or eight petition for type
For motion,
admission
admission of matter which year?
23.
Well, what is the urgency?
Very long time matter not listed, Lord.
Not good enough reason. Sorry. Yes.
My lord, I am also paying for listing of a matter. My lord, 2021 matter.
21.
Yeah, my
What
lord.
is the matter about?
My lord, selection and appointment regard the backlog vacancy of the physically disabled person.
21 matter.
21.
Okay. Next week.
My
Please, Lord.
Item
May I please?
complied with.
Complaint.
Sri S.I. Akand, Learned Counsel, for the petitioner submits that during dependency of this petition, the order dated 1/4/2022 passed in WPC 591 of 2021 has been complied with. Full stop para. In view of the aforesaid submission, comma, this court is of the opinion that this proceeding is not required to be continued any further. Full stop. You are there in agenda 51. 51, we record somebody's name. Who's there? Please say ki Arbor Pujari. Arbor Pujari, A. Bhattacharya. Oh, I also heard 3 R. Bhattacharya. Proceeding. Accordingly, the petition stands closed.
Lord, keep left. May I?
Yes.
Yes. My lord, the petitioner is assailing the impugned communication dated 3rd of February 2023, by virtue of which the petition seeking cancellation of the next of kin certificate that I had since applied has been kept in abeyance, pending the disposal of a succession case that is pending between the parties. To get the facts in perspective, if Lordship is pleased to see the order of this court at page number 39, that is the order dated 26th of October 22, passed in a writ petition, page 39. Relevant portion is at page number 40. May I please?
Page number
Page number 40.
40.
40. This is the order of this honorable court dated 26th October 22. This will more or less give us the perspective on the fact of the matter.
Yes.
Para number 2, may I?
Please.
Yes. On the death of his father, Adilur Rahman, my lord, this has to be read as a brother. There is a typographical error. I am the brother of late Shri Adilur Rahman. The petitioner was aggrieved that the next of kin certificate was obtained by the wife and daughter of the deceased. By suppressing the necessary facts, that the petitioner is also entitled to the said next of kin certificate. Accordingly, the petitioner lodged a complaint before the DC Kamrup on 24th February 21, which was registered as so-and-so for cancelling the next of kin certificate issued to the wife and daughter of the deceased Adilur Rahman.
Hmm.
This writ petition is instituted on the grievance that although the hearing was conducted by ADC Kamrup, but the so-and-so has not been brought to its logical conclusion and no final order has been passed. Considering the limited grievance raised, we direct the learned ADC to consider the grievance and issues raised by all the parties in so-and-so and bring the same to its logical end by passing a final order thereon. We clarify that by requiring the ADC to pass a final order, it is not to be construed in any manner whatsoever that this is a direction from the court to pass an order either in favor or against the writ petitioner. The requirement of this order is that the ADC shall pass its own reasoned order in so-and-so. Let the order be passed by ADC as indicated above within a period of 1 month. So
Hmm.
there's a timeline that was then stipulated from the receipt of the certified copy of this order, provided that the hearing in the proceeding is already over. So there was a fixed timeline that was so fixed
Hmm.
for the disposal of the said complaint.
Complaint. You-
Irrespective, my lord,
You were the complainant.
I was the complainant
Hmm.
before the learned ADC.
Okay.
And thereafter, since there was nothing that was forthcoming from the department, I write at page number 42, I prefer a letter dated 4th of November 22. This is annexure 10, page 40.
Okay.
So this is a very simple, straightforward communication wherein I apprise the learned department about the order and seeking indulgence for the disposal of the said complaint.
Okay.
Irrespective, there was no action that was forthcoming, which prompted me to file a contempt petition.
Okay.
And the same was also disposed of, my lord, by order dated 19th of July 23 at page number 45,
4-5.
45. Pair number 2, may I?
Yes.
Mr. So-and-so learned counsel appearing on behalf of the respondent 1 and 2 has submitted that the order has been duly complied with, and in that regard, Mr. So-and-so, the learned counsel has placed on record a communication dated 3/2/23. So this is the impugned communication, which my lord will find at page number 46, the next page.
Hmm. Okay.
At page number 46.
Next
And-
page.
Yes, please. Annexure 12, my lord.
Yes.
I will only burden the court in relation to the last paragraph. Under the above circumstances, the present petition for cancellation of next of kin is necessary to be kept in abeyance till the decision is given by the honorable court.
Just a minute, Mr.
Yes.
Das. Oh, sorry.
Please.
No, sorry. I will not take this matter.
Oh, I'm sorry.
Sorry.
No problem. Stop that.
Just now I have checked the name.
It will be
This court
placed.
was a council in some cases.
I follow.
List before any other bench without me.
My lord, may I speak the indulgence for a fixed date? If-
You approach the registry, you will not pass any orders.
Please. I'm sorry.
It's a motion matter. It will come. Today is Wednesday. Maybe on Friday it will come. Just
Alright.
approach the registry. Since urgency has been expressed, registry may place this case expeditiously. Yes, what is this?
Lordship, this is a petition for appointment of substitute arbitrator because the first arbitrator that this honorable court has already terminated the mandate of the earlier arbitrator. That's why under section 1115.
We should notice this application is also under 11.6.
11.
For a substitute arbitrator.
Lord.
Where is the earlier cancellation of mandate?
Lordship at page number 6, Lordship, annexure A.
Page 6.
Lordship, page 6, annexure A.
Yes. Where is the operative part?
It is there, sir, lordship. That is, I think, questions, it is for the separate review satisfied. So, that is para number 15, last para, lordship, under which the learned district judge has already sumoto extend the time of the arbitrator that was satisfied in this one.
But where is the recusal or non-continuance of the mandate of the arbitrator? The earlier order is only for against an order of the district
The
judge.
district is so much extended that without either party without having approach. That order has been set aside.
No, that is set aside, but where is the requirement to appoint a new arbitrator?
But there is under section 15, if the arbitrator is mandate is terminated and under section 14, then
Where is the termination of mandate?
Will be de jure lordship.
I'll go to take.
See, this is the earlier High Court's order was against an order passed by the district judge, and High Court interfered. But will that mean that the mandate has also been terminated?
It has been terminated in para number 2, lordship, para number 5 of the judgment, page 8. Thereupon the 21/8/2019 an application filed by the petitioner before the learned district judge Sunitpura Tezpur under section 14 of the Act of 1996 for termination of mandate of the appointed sole arbitrator. At this stage, this court finds it relevant to observe that in view of the provision of section 29A(4) of the Act 1996, the said application was not necessary to be filed in as much as a reading of section 29A(4) of the 1996 Act stipulate that if the award is not made within the period of specified.
The award was not passed within the stipulated time.
It is not.
And the district judge on suo motu had extended the time.
Lot.
In the meantime, due to operation of law, the mandate got terminated.
Lot.
That is your
Lot.
Will issue notice. Heard Sri G.D. Dhiman, the petitioner appearing in person. Full stop. By the instant application, comma, a prayer has been made for appointment of a substitute arbitrator in view of the fact that by operation of law, the earlier mandate regarding appointment of arbitrator got terminated. Full stop, para. That notice be issued. Returnable by 4 weeks.
Kindly fix date, may kindly.
Okay. Returnable on
First week of April, lordship. I will not be here there.
5th of April is okay for you? 5th
Lord-
of April.
Lordship.
Sri B. Chakraborty, learned CGC accepts notice on behalf of all the respondents. Para, let extra copies of the petition be served upon him by tomorrow.
Obliged.
So unilateral appointment of arbitrator by the respondent. Contrary to the
Hmm?
the respondent is unilaterally appointed as an advocate as the arbitrator. The arbitrator refuses to entertain topic. But we are
You're trying to invoke what jurisdiction?
11(6) read with of course the mandate has to be terminated under 14 and 15. It will amount to a substitution because here is a case of de jure termination as opposed to de facto.
No, if you have not given your mandate
Good.
to the appointment,
Good.
the arbitrator will not assume cannot assume any jurisdiction.
He has not. That is the precise point. He has.
So can you challenge them by filing an 11(6) petition?
Well, 11(6) because the termination of the arbitrator's mandate is de jure in view of the Supreme Court's interpretation in Eastman Perkins and TRF Energy and various other cases. My lord. So, my lord, what now happens is that his de jure, his mandate is terminated. He is ineligible. My lord.
No, no, there are two connotations. One is termination of a mandate.
Lord.
And one is not even giving your consent.
Lord.
So as your assumption of jurisdiction itself, you are questioning.
Lord.
It's not a question of
Yes. So, my lord,
termination.
that is why in my relief,
So if a person, he acts without jurisdiction,
Lord.
will say 11.6 lie.
11.6 will lie because my lord, the arbitration has to continue. I am not challenging the arbitration clause. There is an arbitration clause in the partnership deed of 2008, which is there. I admit it. But the question is that, my lord, post Eastman Perkins and the other judgment, this unilateral appointment is, my lord, invalid. But it will have the coordinate bench also, my lord, went into these matters. So the coordinate bench's judgment dated for 5/2/2024. Can we take a look to para 7 on, if I may be. Para 7, Lordship 5.
Yes.
In respect of the proposal put forth by the respondents for appointment of an arbitrator who are employees of the Indian Railway, this court is of the view that persons proposed to be appointed as arbitrators cannot be interested persons. In terms of section
The
12,
matter has been resolved by the full bench, larger bench.
which one?
That interested party, railway's own officials cannot be arbitrator.
But as of today, my lord, the other judgment, that is why I have relied on one short order, my lord, of the Supreme Court, Justice December to 12th of December, my lord. Here also, my lord, the Kotak Mahindra Bank had appointed a full arbitrator of its own. And that judgment was set aside by the Delhi High Court Division Bench, and that was upheld, my lord, not interfered by the Supreme Court. Lordships will see, my lord, that the Supreme Court says from paragraph 6 of the impugned order, it appears to be an admitted position that the arbitrator unilaterally appointed by the petitioner was ineligible to be appointed as an arbitrator by virtue of section 12(5) of the Arbitration Conciliation Act 1996. Hence, in view of this peculiar factual position, no case for interference is made out in exercise of our jurisdiction under Article 136. Well, this was also a case where the bank, Lordships are aware, the banks and insurance companies, most of the insurance companies, they appoint the arbitrators, somebody sitting at Hyderabad or Bombay, they pass the arbitrators and the awards, and creating a very difficult situation for the individual persons. The Supreme Court, my lord, in Perkins has clearly clarified. So here, my lord, the question is that, my lord, what happens when the arbitrator becomes de jure incapable? If I may submit, the Delhi High Court and the Calcutta High Court have gone into the issue in detail. If necessary, I can place those judgments on record. What happens is that, my lord, why 11.6, my lord? Because after
Place those on Friday, we'll have it.
right,
Have-
lord.
On the prayer of three. A. K. Ganguly. A. Ganguly, learned counsel for the petitioner. Matter is adjourned to be listed for motion on Friday.
Good.
Date, huh? Please do so.
Good.
Because the reference, I don't think the larger bench has decided.
I bow down to your lordship. The same objection was raised by the respondent before the Calcutta High Court. Calcutta High Court is examined in detail, and the same view has been taken by the Delhi High Court that termination de jure followed by substitution in accordance with 11.6. So 14, 15, 11.6, both were, three were in group. I'll place.
Okay.
May it please the
Hey,
lordship,
hey,
lordship,
get
the
out.
petition 11.6.
পিছৰটো sir, মোক লাগিব সেইটো বেলেগকে লাগিব দিব নালাগে থাকিব বেলেগকে ৰাখিবচোন Yes, item
May it
number
please- I don't know, 4 lordship.
4, yes.
Lordship, this is the petition under 11.6, lordship, the arbitration clause is at page 68. Notice,
60,
page
Page?
68, lordship. My operative part is at page 69. lordship.
69, which clause?
Second clause, lordship, clause 64, 3A2. May I read?
Yes. Issue notice at this stage. DJ Kapil.
No.
Heard 3 DJ Kapil Learned Counsel for the petitioner who has filed this petition under section 11 within bracket 6 of the Arbitration and Conciliation Act, 1996 for appointment of an arbitrator. Full stop. The Learned Counsel has referred to the concerned clause 64,
Page 69.
concerned clause 64 within bracket 3 within bracket A within bracket small 2, page 69 silo, which provides for an arbitration process for resolution of disputes. Full stop. Para, let notice be issued. Returnable by 4 weeks. Ms. R. Devi, Learned CGC accepts notice on behalf of all the respondents that extra copies be served upon her by tomorrow.
Highly.
Second file taken here, Kibra? Huh? দেয়া নাই এটা। কেউ অ্যাডভোকেটের নাম কেউ দেখুয়া নাই? কেউ দেখুয়া কেউ নাই? None appears for the petitioner on call, full stop. However, it appears from the cause list that the name of the council has not been reflected, full stop. Para, registry to reflect the name of the council and list this case for motion on Monday, 18th. এটা অলপ দৃষ্টিগোচৰ কৰাব লাগে দেই, কিয় দেখুৱা নাই? এডভোকেটৰ নাম আছে নহয়। Yes.
Matter relates to ex-gratia payment of road accident, your lordship. On the last occasion, your lordship, the honorable court passed an order and directed the respondent authority to release the ex-gratia amount to the petitioner. your
Page.
lordship. Page, your lordship, to find 11. Paragraph 8, your lordship. Very.
Yes.
As the petitioner has already produced a copy of next of kin certificate, it would be open to the office of the Deputy Commissioner of Goalpara to cause an appropriate inquiry and to release the ex gratia relief to the petitioner within the period of 50 days from the date of receipt of the certified copy of this order. The petitioner shall produce a certified copy of this order.
Okay. Your S. Islam,
As is stated.
or 3 S. Islam Learned Council for the petitioner who has complained of non-compliance of the directions contained in the order dated
19/7/2020.
19/7/2023 passed by this court in WPC 8229/2022. Full stop. Para. The Learned Council has also referred to the representation dated 17/8/2023 to the respondents requesting for compliance. Full stop. Para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps by tomorrow.
Date may be fixed, your lord. Date may be
Contempt
fixed.
matter.
Of like.
May,
Yes.
if,
Relevant order is then page 24 start from,
2-4.
and the relevant portion is 27. Hearing unauthorized construction uh, by my neighbor. 6 and 7 is my lord.
Okay. Okay. Heard 3, Anne Borman.
Hello.
Learned counsel for the petitioner. Okay, huh? In order hold. 11/8/2023, WPC Hall, 1734/2017. Representation Hall, 28/8/2023. Same, huh? It's a notice, 6 weeks. 6 steps by registered posted daily by tomorrow.
Well. Tip level.
Wait. I've come with a contempt application, my lord.
Where is the order?
That is at page 84, the relevant portion.
Yes. Yes. Yes.
My lord, I had come with a writ petition, my lord, with being threatened of eviction, my lord, staying for decades. Now, in spite of that interim order which has been served upon them, they entered into the area, my lord, under possession of the petitioners. And my lord, may kindly see page 93,
96.
93.
93, yes.
My lord, with the tractor, my lord, kind of the state behaving like this, page 93.
Yes.
They came with a tractor and raised our crop, my lord. And at page 94, 95, my lord, may kindly see, they have fenced the whole area. And the situation arising out of this at page 99. Can the state really act like this? Now they are inside, those who are inside, they are inside, they cannot come out. So exams going on for the children, and this is the situation there. So it's like kind of a travesty of justice, and if the state behaves like this, what do we?
Where is the statement that who is involved in this?
I made them respond, those who are involved. I have stated in
When did this begin?
this on 3 March. Where? 26th of February,
Where have you stated?
paragraph 5 at page 27.
Please read.
Page 27. That the respondents, in a desperation to vacate the land possessed and in occupation of the petitioners, to facilitate allotting the same to persons wielding powers and influence, has this time giving a complete go by, and in willful and deliberate violation came with men, materials and tools on 26th of February and demanded the petitioners occupants of the land to vacate the land immediately and not later than week, as the petitioners have been threatened to be forcibly thrown out and their houses will be razed to the ground. The petitioners who were present there at that time pleaded with folded hands to spare their homes, their cattle, poultry, and crops. And they also mentioned that they had approached the Honorable High Court and were protected by interim orders, which were already submitted in office of the respondents. The respondents and the representatives and men who were present at the site reacted, saying that they had orders from the superiors to carry out the eviction.
Where is the initial order, madam?
That is at page 51. Wherein on the first day interim order was granted, but somehow it was not reflected in the order. And therefore we filed an IA And the petitioners are not staying there from recent time, from decades they have been staying.
What has happened to the case?
It is pending, my,
But you have made, whom have you made parties?
my lord.
Whom have you made parties here?
I have made the deputy commissioner.
No, the principal secretary, will he come to evict? Debo Kumar Mishra, deputy commissioner, the principal secretary.
Now what they have
Who had come? Where have you stated?
what they have stated is that they had orders from the superior. Definitely, it has to be the departmental superiors, or unless I do not know who superior ordered them.
We'll have the writ petition for hearing.
My lord, that is already in the process of the matter.
We'll have
posted
it
for hearing.
tomorrow for hearing.
Day after.
Tomorrow or Tuesday. Because this matters, if the court was of the opinion that you are entitled to an interim order, definitely there may be some merits in your case. And the intention of the court was also to have an expeditious
Hearing.
disposal.
Correct.
Let us have it, it's a matter of 2022. Why not tomorrow? Tomorrow, what is the difficulty?
My lord, I have some matter
On
in
Friday then,
Meghalaya.
Friday.
Right.
Friday. Along with this, okay? If we see
Okay.
that there is something very, which is not in accordance with law, then we'll issue notice in this.
My lord.
Let us see. Heard MSBS Goel, Learned Counsel for the petitioners, who by means of this application has complained about violation of the directions contained in an order dated 2/3/2023, passed in IA number so and so, arising out of WPC number so and so. Full stop. It is submitted that in spite of the clear restriction imposed on the respondents regarding evicting the petitioners from the land under their possession, on 26/2/2024, a number of petitioners have been evicted and the lands and structures have also been
Confined means not really evicted, confined.
have been confined, and the land and structures have also been damaged. Full stop. Para, it however transpires that in spite of the observation of this court to have the writ petition decided expeditiously, the same is still pending. Full stop. Para.
Let it come.
It is accordingly directed to list the connected writ petition WPC 8309/2022 for consideration on Friday, along with the present case.
I'm so grateful.
Who is appearing in the writ petition?
My lord, Revenue Department,
Okay. Have they filed affidavit?
or only, I'm told only the deputy commissioner has
Okay.
filed, not the other.
We'll interact with the council. If this
Fine.
is happening, then you may have an effective remedy in fact.
Yes, I'm so grateful.
Madam Borman, just inform your colleague in the revenue department about this case.
Yes.
Oh, okay, madam, you're there. This matter will come up day after tomorrow, the main matter. There is a restriction on eviction, but they alleged that on 26/2, some activities have been done in violation of that order. And the writ petition was directed to be, as you have heard, to be listed expeditiously. It has not been done. Okay. Yes, next. Item 9.
Right, please, Lord. All of this item to be taken up along with item 39, my lord, from the same FIR.
Okay, yes. Yes, we'll have it.
Good. It is,
Item 39 from the same affair.
Okay, we're having it 39 both.
Yes. 39 advocate for who? Advocate for who?
However, in Article 39, respondent is not here. Informant. Is a POCSO case.
POCSO matter. And 39, who is appearing? Mr. Ali, you're appearing.
Earlier, my lord, rejected 3 persons in same petition. And at present, my lord, the learned friend filed for 1 petitioner and I am for 2 petitioners.
Okay.
The reject order is the same. And this time, my lord, I have annexed this document, my lord.
ID card has been received by the registry. Copy. Janavali. It's been served.
Good.
They have not appeared. And in one case it's served, so we'll deem that it's served.
Good.
Yes.
My lord,
You're in 4344. Who will be arguing first? Which matter?
44.
Okay.
My lord, in this case, my lord, the allegation is that, my lord, the you
Let's
lost,
see the initial order.
my lord, kindly just 1/6, my lord.
Just a minute. Just a minute.
Last part, my lord,
Earlier order page
is 1/6, my lord.
16.
Yes, the relevant part, my lord.
Okay.
Main order, my lord, is 15, last, my lord.
Hmm.
Last, my lord, 3 Vaishnava.
Yes, please.
3 Vaishnava learned additional PV referring the case diary and the more particular the statement that it is alleged victim the recorded under on 54 therapist has committed the version of made by the applicant are not substantive and the rather than the support of the maid in the affair. The learned, my lord, kindly last part, my lord, the learned additional further submit that in her statement specific allegation have been made against the applicant number 1 and 2, my lord. I am the 3, my lord. Specific allegation regarding the 1 and 2, my lord.
3 what? 3 is concerned. with
And
the-
at that time, I am the VT member. That record was not annexed. And now I may annex this document.
Okay, please read further.
And medical also not examined, my lord. Whether it is also medical report was not evaluated. This is the VTB President and Secretary. I am the active member of the that. This 1/8.
Which document?
1/8, my lord.
18.
Yes. Central Fund.
What is this?
My lord, the petitioner is the active member of the VTB city. For that time, my lord.
Please read.
This is to certify that the Mirazul Islam, son of Abdul Hanif Khalis, Nolirpar PS Talmara PS Kampo in the district of Nagaon, Assam. The above person is the active member of our Nolirpar Village Defense Party. He played active role in preventing the commission of illegal activities in the society. I know him very well as such. This is the true and certificate.
Yes.
In fact, my lord, the particular day, my lord, when the victim girl was slaughtering with two boys, and they are the victims, they are in duty, man. When they was death, they was asked for their result is confusion. So later on, my lord, both the parties, my lord, the victim.
Who are the two boys? Mr. Odin's client.
Correct.
Who are the other two boys?
So much. My lord, the other two boys, my lord, that is FIR, my lord. I mentioned, my lord, in para, my lord, two boys, my lord, that two boys, my lord.
Abu Ansar and
Abu Ansar, my lord,
Zero Sir.
that two boys.
Age?
Page, my lord, 4 from first part.
No, no, FIR.
No, my lord, my petition, my lord.
No, no.
FIR, there is no specific person, my lord. Their name not mentioned, my lord. But in fact, my lord, original fact, my lord.
That is your version.
Yes, my lord.
That the girl was found loitering with two boys.
Yes, my lord.
And you are VDP party.
Yes, my lord.
All of you.
Yes, my lord.
And you tried to, okay. Oh, yes, we have read, last time we have had a look at the statement of the victim.
Sure.
You have it?
Actually, fact is that, my lord, the informant's daughter, my lord, on particular night, my lord, she was roaming with two boys. I have mentioned the name of the boy. In my case, my lord, page 4, last 3 line, my lord. That I am reading, my lord, the relevant portion. The present petitioners are the members of Nalipara Village Defense Party of that village. They found the victim girl was roaming with two boys, namely Abu Ansar and Jirat Ali of Bajbhata Meri village. The petitioners found
What
that,
was the time?
my lord,
What time?
my lord, at 2 p.m., my lord, 1:30 a.m., my lord.
1:30 a.m.
a.m., my lord. Thereafter, my lord, after caught the girl and that boy.
1:30 a.m. she was roaming with two boys.
Yes, my lord.
Where?
My lord, of that area, my lord. Or village area, because they were on duty. The present petitioner and my friend's petitioner.
And those two boys, they are residents of which place?
But they are from Bajbhata Meri village, nearby village, man.
Did you catch them also?
Yes, my lord. Thereafter, we have informed the both girls' parents and the boys' parents, and they have taken. And after 13 days, my lord, both party, my lord, jointly filed this petition on that ground only. Why we have, my lord, caught them, and there is, my lord, some prestige issue, and they are thinking.
When was the incident?
And after 13 days, my lord, affair was lost. After thought, the incident, my lord, prepared incident, my lord. And therefore, my lord, the affair was lost, attempt, my lord. In fact, they have attempt. A very unfortunate case, my lord. 3 persons at night, my lord. I have also annexed the certificate of that president, secretary of that village defense party, page 15, my lord. One is the student and other is the cultivator. Page 15, my lord. So both party now they have a good relation, man. Both the boy's parent and the girl's parent, they are in good relation and jointly, my lord, they are thinking why, due to our duty, my lord, already their prestige has gone. Therefore, they have lost this affair. And after 13 days, my lord, such a case, my lord, nobody can wait, my lord, till 13 days, my lord. And last occasion, the Honorable Court observed, though the advocate placed before the Honorable Court, they are the village defense party, and the story was the same, but no documentary evidence was submitted. The Honorable Court will not observed in the order.
Okay,
Last part, my lord.
let us have a look at the.
Yes, sir. Page 19.
No, let us have a look at this case diary. What is the name of the victim?
Victim name is, my lord, here in the affair, Salma, my lord.
Umeesha Salma.
Yes, ma'am.
What are your names?
My petitioner's name was Abul Basar and Khurshid Alam.
One 164 is against you. You have been named.
Yes, my lord. But the problem
the
is here.
victim?
One thing is examined, my lord. Suppose,
Poxo.
yes, my lord. Suppose the incident is true, my lord. Then on the stand, FIR should be filed. After 13 days, thus a, my lord, allegation is very impossible, my lord.
See, at the stage of grant or non-grant of bail,
Because-
we are on the prima facie allegation, 164 statement.
Why?
This is not a trial. You get your full chance to cross-examine.
Yes,
Why FIR was
Sir.
lost 13 days with 13 days delay?
My lord,
Explanation of delay is there, Lord.
No,
If
my
you look into the FIR, Lord,
that's the ground, my lord.
page 11, Lord.
Well, it is not the, my lord, reasonable ground of delay
Not
lodging the
there, Lord.
FIR. Because a girl was there intent allegation against us, attempt to, my lord, commit rape. And
Intoxicated.
13 days they are waiting.
More.
well,
Last, Lord.
13 days after, my lord, FIR will not be lost, my lord. It is after thought a story
Explanation is-
prepared, my lord. That time they could not prepare their mind, my lord. Now both parties jointly, my lord, lost the FIR.
Just a minute, just a minute. The 161 and 164 are consistent.
Delete out only examine, my lord. Because in criminal case, my lord, the incident is very serious, but 13 days delay is very suspect, man. Otherwise, police station is very near. And our case is that we have handed over the girl and 2 boys with both parents. And they are jointly now against us. That means their issue is that due to our activity, my lord, they have lost their prestige. That is the case, man.
Sorry. The statement is there.
My lord, when they are interested to, intention is to harass us, my lord,
It's an AB, not even a BA.
but the defense, my lord, village defense
Sorry.
party also,
So for my case, my lord, my name was not,
Your name is
Miraj, my
there.
lord. And
Your name is there.
not specific, my lord. Kindly
Your name is there, specifically there.
And Mirazul is not
Yes, it's there in 164.
Miraj.
an offense also not
Is
committed,
there.
my lord. Here is
It's
section
a
8 is
different matter. We have already recorded in the last order that when hue and cry was raised, you fled away. Heard. So and so, Duta. So. Both these applications filed under section 438 of the CRPC pertains to the same Kanpur PS case number so and so, file number so and so. Full stop. Initially, a common petition was filed by the 3 petitioners in AB 2945 of 2023, which however was rejected by this court wide order dated 18/10/2023. Full stop. Such rejection was after perusal of the case diary, which included the statement of the alleged victim under section 164 of the CRPC. Full stop. Para. 3. Which case is first?
my lord, first 294, man, AP 294. Abul Bastar and that.
3. Ainuddin, learned counsel for the petitioners in AB 294 of 2024 has submitted that there is a long and unexplained delay of 13 days in lodging the FIR, which itself raises serious doubts on the veracity of the case lodged against the petitioners. Full stop. It is also submitted that towards their claim that they are VDP members,
Yes.
certificates have been annexed to this petition. Full stop. Para. 3. Mr. Ali, you are for which matter?
4344.
4-3.
Double.
Item number?
39.
You are not there, your name is not there.
Yes.
Hmm?
Basically, nice.
In the cause basis name, 3 Charlie, Planet Council appearing for the petitioner in AB 4344 of 2023 while supporting the submissions made by Sri Uddin has further submitted that so far as his client is concerned, there is no specific allegation of to connect himself with the alleged offense. Full stop. It is further submitted that the petitioners were part of the Village Defense Party and had detected the alleged victim with 2 other boys, and on such detection had handed over the alleged victim to her parents, and only as a counterblast, the instant FIR has been lodged. Full stop. Para. Sri K.K. Das, the learned APP, by referring to the has at the outset submitted that the prayer for anticipatory bail having been rejected once, unless new grounds are made out and urged, there may not be a scope even to examine such a prayer. Full stop. He submits that so far as the documents annexed in support of the contention of the petitioners that they belong to the VDP, this court in the earlier order had already taken note of the submission and had also come to a finding that even if the petitioners are members of the VDP, that will not itself absolve the petitioners from any criminal liability. Full stop. Para. Be that as it may, the case diary produced has been carefully perused, which includes the statement made by the alleged victim under section 164. Full stop. The version made therein is consistent with the statement made before the police under section 161 CRPC. Full stop. Though there appears that there has been delay of 13 days in lodging the FIR, the FIR itself states reasons for the said delay, and in any case, in an offense under the POXO Act, the question of delay can be a question for determination at best in the trial and not at the stage of the consideration of a of an application for anticipatory bail, full stop. In view of the above, both these petitions are rejected. Para, the case diary is returned. Yes.
Doctor, this is subsequently started submitted, doctor, accordingly, someone was issued the petition of. So, doctor, the offense under section 31A of the Assam Capital Act.
Why don't you appear and seek bail, regular bail?
Doctor, he did not appear.
Now, why don't you now go and appear if the charge sheet has been submitted? You appear. We grant you liberty to appear.
But earlier, one order was that submit one order you lost already passed.
That we have seen, that the rejection order we have seen.
Yes.
So any observation made by this court towards maybe supporting the earlier order may not be in the interest of justice so far as the petitioner is concerned. Since search sheet has been submitted, you can. We are already passed an order earlier. Why,
Yes,
why
that
haven't
is
you
why-
gone? Why haven't you gone?
Okay. Some protection.
How can we grant protection? You seek regular bail. Is there any scope now?
Yes, okay. That is argument plus six. If submitted, there's no bar to grant.
There is no bar, but this is AB. This is not even a bail application.
Yes, doctor, that order is also.
We don't find any reasons to entertain this petition.
Substantive, the doctor put the argument, doctor, in case of he is submitted, doctor, till then, doctor, for 38 is maintainable, doctor. And court has.
We have already passed an order. That order is not put to challenge. The case law may have good value, but here there is an order
Yes.
of 10/1/2024. We are neither rejected nor we have not said anything. We have asked you to appear. Heard. Sri, your
Is it?
A.Z. Ahmed learned counsel for the petitioner, who by means of this application has prayed for. An application filed under section 438 has prayed for pre-arrest bail in connection with so and so. Full stop. Para. Sri K.K. Das, learned APP, however, has submitted that the petitioner had approached this court on an earlier occasion with a similar prayer, which was considered on 10/1/2024 in AB 3843 of 2023, full stop. By referring to the said order, comma, the learned APP has submitted that on being informed that the charge sheet was already submitted, comma, the petitioner, and the petition was closed by giving liberty to the petitioner to approach before the learned trial court and pray for regular bail. And in such event, the application was to be considered and decided on its own merits. Full stop. Para.
Even
Para. We, after hearing the parties, comma, this court is of the view that when the aforesaid order was already passed, comma, the present petition itself may not be maintainable. Full stop. This court had also recorded in the last order the charge sheet, the details of the charge sheet, which is numbered as 433 of 2023, dated 30/11/2023, filed before the learned CJM Dhubri. Full stop. Para. In view of the above, the instant petition is dismissed, full stop. However, the direction given in the last order dated 10/1/2024 by this court would prevail.
I'm over.
May please your lordship, I am appearing on behalf of engaged counsel Devu Sharma. He is unable to present today due to some of his personal difficulties standing matter may be adjourned for the date.
Okay, just a minute. Madam. Cindy office note dated 6/2/2024, as per which it has been reflected that the necessary court fee has been paid, full stop. Para. A prayer for adjournment has been made on behalf of the learned counsel for the petitioner, full stop. Para. Friday, is it okay, madam? Friday,
Friday,
day after tomorrow,
after 21st March, any date.
as requested. After 21st March, why? As requested, list after 2 weeks.
To 20,
After 2 weeks.
do it. Obliged, lord.
May please.
Yes.
My lord, there was a annual patta land. So subsequently, your lordship, the petitioner has purchased it and applied for conversion to the Mayadi patta. And then lordship, it was not done, then the petitioner filed a revision petition before the Assam Board of Revenue. Assam Board of Revenue lordship, is 30 lordship, directed the DC Nagaon to consider the settlement in the name of the petitioner. DC referred it to the Basundhara, land through a land advisory committee. So Basundhara is lordship when the land was converted lordship, land become, because lordship, if the annual patta is transferred, it is first NR case is started, and then the annual patta is cancelled, and then it again settlement is given in the name of the person who is in possession. So this is my only prayer, lordship. At this stage, I am praying only for issuance of it.
No, what is your grievance? If it is sent to Vasundhara, that is the scheme which is
Basundhara
operating.
lordship, Basundhara, as per Basundhara scheme lordship, what will be done? That list has been given. So if a land is a annual patta land, for conversion, it can be referred to the Basundhara 2 lord. But what happened, your lordship, when the NR case was started, the land became the government land. So Basundhara cannot decide. I am having the Basundhara scheme copy.
Yes, madam, what do you say?
I am not praying for any stay, simply to.
Then my response may come whether that can be.
No, what
accepted.
Mr. Roy is submitting,
Right.
that it is only in respect of AP land, annual
Yes,
patta
manual
land,
patta land, not in
where
annual.
Vasundhara scheme is applicable, not for khas land.
Yes, section has to be. Right.
Hard 3 SP Roy, Learned Counsel for the petitioners. Full stop. It is the case of the petitioners that on the strength of a power of attorney by deed number 129 of 1988 in favor of the petition number 3, comma, they are in possession of a plot of land measuring 14 bighas and 8 lechas covered by DAG number 970 of AP number 95. But this is already an annual patta land. What is the difficulty
So,
for conversion?
we have filed application for conversion to Patta.
No, under Vasundhara, what is the difficulty?
Under Vasundhara Lordship, only the Lordship here, when we applied Lordship for, and a non-renewal case was started by the ADC, so land become the government. And then the circle officer recommended for the settlement of the land in the name of the petitioner. That I have met the, filed the enacted.
It is the case of the petitioners that they had submitted an application before the circle officer for conversion of the said plot of land. Which, however, was negated by the ADC, Nagaon, by the order dated 1/12/1994. Full stop. The aforesaid order was the subject matter of challenge in an application or appeal
Revision Lordship under 151, page 30 is the judgment.
in an application dated 19/12/2008 purportedly filed under section 151 of the Assam Land and Revenue Regulation before the Assam Board of Revenue, within bracket ABR, which by the order dated 6/1/2009 had remanded the matter to the Deputy Commissioner. However, by a recent communication dated 27/9/2022 issued by the circle officer, comma, the petitioners have been informed that there is a proposal sent to the ADC Revenue to be placed before the Land Advisory Committee, wherein the petitioners should apply through Vasundhara 2, Roman 2. Full stop. It is the contention of the petitioners that the aforesaid scheme is not applicable for the land in question. What were you doing from 2009?
Lordship, the matter was pending before the ADC only, sorry, at ADC.
From 2009?
Circle, and then first circle officer Lordship, and lastly Lordship, the circle officer recommended for settlement Lordship. That
Not from 2009, what were we doing?
2009, we have filed the petitions Lordship.
From
before
2009 to 2024, what were we doing?
the matter was kept pending long by DC Lordship, then it was referred to circle officer.
This court has, however, noticed that there is an unexplained delay
I'll file my additional.
in from 6/1/2009. And the communication of 2022 prima facie does not appear to be connected with the initial cause of action, comma, if any, full stop. Let a proper affidavit be filed explaining the delay. And only after being satisfied, comma, this court may entertain this petition.
Obliged.
May I plead your Lordship, my senior is in another court. Can a matter may be taken after some time?
Why education department? Why? What is the matter? You have the brief or not?
This matter, my lord, they have alleged regarding the non-participation of guardians of the school students, my lord, in the school management committee. Some allegation has been raised against that person concerned, my lord. They are the respondents here, private respondents. And now this writ petition has been filed for to make a direction from the honorable court to arrest those persons, my lord. As the affair has been filed and no consecutive action has been taken against this person.
Let
So
us
it's
see.
barred by Sakiri Basman. If they have filed any FIR for the concerned police official,
Who is the senior?
Arali.
Call him.
page 34 is the FIR. Officer in charge, Moraja Police.
34 is.
Anita 6.
So nice, baby. Okay, let me start, Likon. Madam, you are for education department. List after 2 weeks to enable filing of such affidavit.
1, 2, 4, and 5.
Let him come.
My
Yes.
May I plead, Lord? This is a case of land acquisition in respect of four laning over flyover at Testpur. On the last occasion, the government side has sought some 10 days time for inspection from their client.
Have you received the instructions, madam?
My-
What is there?
It's matter, my lord, that the instruction says statement regarding acquisition and all today morning this you will acquire this. The acquired land measuring is the 1 quarter 4 lesser. Their contention was no area was mentioned in the acquisition notification, my lord.
What is your name, Mr. Counsel?
SK Bhattacharya.
What is your prayer here?
My lord, a notification has been issued, it is in page number
No, no, what is your prayer? What
My,
relief are you
my,
seeking?
my land has not been properly demarcated, earmarked. Which part of a portion of my land is to be taken by the concerned
Acquisition
department?
process.
Yes.
But
And no
the-
compensation or Jirat has
they
been
have,
made.
they have assessed the compensation at 8,13,360.
They have not informed the same to us.
No, no, that is the instructions.
Fine. That section says,
Why don't you
Kindly, my
issue,
lord, in
why
page
don't you
number
issue a communication to him based on these instructions?
page 25
Yes,
is the notice, which was received by my brother who is in adjacent land of myself.
25.
Page 25.
Yes,
It was received by my brother. This land is adjacent to me. And
Hmm.
my brother has told me that there is an instruction for you that a same notice has been also issued.
but
And
you have,
according-
you have not received.
But I have not. Accordingly,
Okay, there
Yes.
is, there is, what is the otherwise status of the acquisition proceedings? Acquisition is for what? A flyover?
acquisition for pole and flyover.
4 and 5.
What is the status? See, there is an interim order. In matters of infrastructure, we don't like to
My lord.
have an interim
My
order.
lord, kindly,
If he is entitled to
Yes.
the compensation, whatever entitlement he should get,
Yes, my lord.
that is
That
our
okay.
prime purpose. And
Fine.
it should be in a transparent manner.
My lord.
in this regard, we have also filed an application that is in page number 31.
Yes.
And it has been filed in way back in August 2023, but no reply has been received from us.
See, unnecessary is,
Fine.
you have made him come to the court. You could have settled this kind of matters. Why should one come to the court?
Wherein also we have stated that we will leave that, we will cooperate with
You
the,
issue a communication immediately.
My lord.
And
I will inform the,
And maybe based on this, he can withdraw this
Fine.
application.
let it be on Friday, my, that I can.
On Monday next.
Fine.
Okay. You come from Tezpur or you are a
No,
local?
I am from,
Tezpur.
no, from Guwahati.
Okay, no problem. Monday we'll have it. Okay. Pursuant to the order dated 28/2/2024 of this court, Miss M. Borman, Learned State Council, has obtained the written instructions dated 9/3/2024. Post up. As per the same, the land which has been acquired of the petitioner measures 8 lechas, for which an assessment has been done to the tune of rupees 8,13,360 bracket so and so. Full stop. Para. Let para 3 Bhattacharya, the
Yes.
learned counsel for the petitioner, however, submits that at no point of time any notice of acquisition or any information about assessment have been issued to the petitioner. And it is only because of the said purpose that he had to approach this court. Full stop. Para. List this case for further, list this case on 18/3/2024. Full stop. In the meantime, the respondent authorities may issue appropriate communication towards the details of the land of the petitioner which has been acquired and the assessment made. You take this back.
My lord.
We'll have it on Monday.
Obliged.
Ensure that it is done prior to
My
date.
lord. I will.
Maybe Lord. The matter parting regarding the comprehension, my lord. The petition, respond number 6, the original, my lord, owner of the land, my lord. And the agreement was made before Jute Corporation of India, my lord. And thereafter, my lord, when the,
Who are you?
my lord, I am the gift, the respond number 6 gift me land, 15 lesser of land to my father, and subsequently it was mistreated in my name.
A gift was by registered deed.
My lord, my lord, the land was mutated in my name and restitution also. my lord, Namjari also, my lord, case number, my lord, 21, my lord.
Now you are the owner of a plot
yes,
of
my
land.
lord,
Why
I'm
are
the-
you going to the respondent of 6? You are the owner
I'm the
on
owner.
on the strength of a gift deed.
Yes, my lord.
Okay, your name has been mutated.
Yes, yes, my lord.
Okay, what is
Now-
the area of the land?
15 lesser, my lord.
15 lesser.
Yes, my lord.
Hmm.
And the municipality demolished my house, my lord, on notice, and on 20 only on the 40 hours time.
When?
My lord, 22 December, my lord.
Last year.
This year, last, my lord,
26 December.
26 December.
Last year, 23.
Yes, my lord.
Case 38 is the order.
You said this year. This year, December is yet to come.
Last year, my lord.
26 December.
Yes,
Okay,
my lord.
demolished.
Demolished, my lord.
Okay, now you are seeking compensation.
Yes, my lord.
See, Mr. Ali, your entitlement to compensation, we may not
My
doubt.
lord, we applied, file an appeal immediately, my lord. My lord.
No, Mr. Ali,
Yes, my lord.
your entitlement we may not question, but can we really make an assessment by
Lord,
sitting in as a
My
writ
lord,
court?
if the notice is issued, my lord, the municipal will be assessed, they demolished, my lord.
No, these are matters where needs to be, you need to adduce evidence.
Evidence is required regarding.
What is your instruction? Any instruction?
No, my lord, it has come for the.
Okay. No, it has come earlier.
No, earlier it was adjourned from their apartment. No order.
Okay. We'll see if the demolition has actually taken place. It is indeed a serious matter only because there is an existence of alternative remedy, but we'll say something, okay? Heard Sri H. Ali Learned Counsel for the petitioner. It is the case of the petitioner that an area of 15 lachas was transferred to the father of the petitioner by the original owner, the respondent number 6, by a gift deed in the year 2009. Full stop. Over the said plot of land, comma, A type house was standing, which was put on rent with the Jute Corporation of India. Full stop. It is the case of the petitioner that subsequently, his name was also recorded in the Chitta pertaining to the said land and in the order of mutation. Full stop. However, comma, no, there was a notice not to construct. Full stop.
There was no any construction. This construction was earlier construction, my lord.
On 30/11/2023, comma, the respondent number 3 had issued a notice to the petitioner to stop unauthorized construction over the land in question. Full stop. It is the case of the petitioner that he was not making any new construction.
Yes.
Full stop. However, comma, on 26/12/2023, comma, the structure existing thereon has been demolished by use of bulldozer. Full stop. The petitioner, comma, by means of this petition, has sought for compensation to the tune of rupees 10 lakhs. Full stop. Whether a writ petition with the aforesaid relief would be maintainable is would itself be an issue which would arise for determination, inasmuch as the relief sought for has to be proved in accordance with law by adducing evidence. Full stop. Para. Be that as it may, that notice be issued, returnable by 6 weeks. Miss M. Bormon, the London State Council.
2 and 5 I am appearing.
MAD, Municipal Administration.
I can.
Oh,
1,
1,
2 and 5.
1, 2, and 5.
Rest has to be by registered.
1, 2, and 5. Extra copies. Let steps for service of notice upon the respondent was 4, 6, and 7 be taken by registered post with AD, steps by tomorrow. The maintainability of this writ petition is, however, kept open.
Lordship, on earlier occasion, I have prayed for change the Annexure 6 law.
Okay.
The Honorable Court has allowed me, but due to non-reflecting the observation, Lordship, the registry did not permit it to change the Annexure 6 law.
Have
And
you changed? Not been able to change?
Actually, no, Lordship, the observation was not reflected. Actually, what happened, Lordship, I have annexed page 153, Annexure 6, that is representation dated 10/1/24, Lordship.
153.
153, Lord.
Yes, this needs to be before whom? PCCF or what?
This is
The
this
ICC
representation.
Deputy Commissioner.
This representation is 10/1/24, but I have explained in my petition in paragraph 7, representation of 21/3/2023, Lord. That is the difference. I have by mistake I have annexed this
It
one.
doesn't matter. Will it make a difference?
Actually, I have by mistake I have annexed different.
No, will it make a substantial difference in the adjudication process? If not, you can carry on. Otherwise, we'll grant you to change. Mr. Goswami, what do you say? Is it a substantial, will it make any substantial change?
Not necessarily, and otherwise, my lord, section 25 wildlife protection has said, if their lands are their own paksa land, my lord, they can claim compensation under Land Acquisition Act. So instead of coming to this honorable court, my lord, he could have initiated that proceeding before the DC. Unless, if my lord issues notice, I have no objection, but he will be losing his own time. My lord. Finally, he has to go there. Section 25 wildlife protection.
We'll issue a short notice. We record your submission, and in the meantime, he can have the instructions to save time. Okay. Yes, Alam.
MS Alam.
MS Alam.
Yes.
Heard. 3 MS Alam. Learned Counsel for the petitioners. Full stop. It is the case of the petitioners that they are in possession of different plots of land which has been described to be Miadi Patta, /Tozi, /Khas, which however was not a part of the forest land, but under the Chitalmari Pothar Revenue Village. Full stop. The petitioners claim to have constructed structures and houses thereupon. Full stop. It is the case of the petitioners that on 16/3/2023, they were evicted pursuant to eviction notice dated 20/1/2023. Full stop. By means of this petition, the petitioners have prayed for compensation and rehabilitation. Full stop. It is also submitted that representations representation S9 in this regard was submitted on 21/3/2023. Full stop. The learned counsel for the petitioner, however, clarifies that while annexing the said representation, comma, due to inadvertence, comma, a later representation of 10/1/2024 has been annexed. Full stop. Para. Let notice be issued. Returnable by 6 weeks. Sri P.N. Goswami. Revenue. Ms. G. Hazarika, the Standing Council Revenue Department, accepts notice on behalf of respondent 1. Home and Political. Mr. Goswami. Sri P.N. Goswami, learned AAG, accepts notice on behalf of respondent numbers 2, 3, 4, 5. What about ADC revenue?
Let we take all the notices along with my,
Oh,
that'd be better. I'll be appearing for all along with my.
okay. Sri P.N. Goswami, learned AAG, accept notice on behalf of all the respondents. Full stop. Ms. G. Hazarika, learned Standing Council Revenue, is also present. Full stop. Para. Sri Goswami, the learned State Council, however, submits that from the averments made in the petition, comma, it is not clear as to the nature of the land in question, as a vague expression has been used of Miadi /Tozi /Khas. Full stop. He otherwise submits that in case the land in question is Miadi
Proper
Patta
to-
land.
For a petitioner would be to take recourse to section 20.
No, in case the land is Miadi Patta land, comma, section 25 of the Act, name of the Act. Section 25 of
Wildlife Protection Act 1970.
1972 of the Wildlife Protection Act 1972 can be taken recourse to. Full stop. Para. Let necessary instructions in this regard be also be taken by the learned counsel for the petition. List after 6 weeks. তার উপর দিলে accepts extra copies লিখিব. Extra copies by tomorrow.
Yes, sir.
Right.
Yes, but matter relating to my lord, mutation of the land of the petitioner. Petitioner is possessing a part of land, patriotic patta land, 1/5 less at Disney town. And she applied for mutation of her name. And thereafter, my lord, the Mondol has submitted the report. And then the matter has been kept pending. And ultimately, my lord, by order dated Last on page 22, matter was referred to the BTC authority for approval. Whether it is required or not, it is not clear since 2020. Just sitting over the matter. In the meantime, petitioner has understood the matter and filed a representation, page 21. And nothing has been done well. So my simple prayer is that my case may be decided and order may be passed either to allow or to reject.
My lord, as per Assam right of public service.
Now that will be on a different footing, that if we take into recourse the Assam Public Services Act, where mutation is one of the fields which has been laid down as public service. We can, will it help if we dispose of, give you the liberty to approach under the Act? I saw, yes. Or will you obtain some instructions? Let us have it on Wednesday.
Right letter, but not.
You have already written.
Written. 128.
Okay. Heard. Madam Borman? Madam Borman will dispose this of? No, we'll dispose this of in the line of the earlier cases. Heard Sri S. Nath, Learned Counsel for the petitioner. Also heard Sri P.K. Mushari,
R.K. Mushari.
R.K. Mushari. R.K. Mushari, Learned.
2, 3, and 4.
Also
3, 4,
heard,
and 5.
also heard Miss G. Hazarika, Learned Standing Counsel, Revenue Department, comma. Sri R.K. Mushari, Learned Standing Counsel, BTED, for respond numbers
4 and 5.
2.
3, 4, and 5.
What about 2 district advocate? 2 is by M. Borman, State Council. 3, 4, and 5, R.K. Mushari, Standing Council. Para. Considering the subject matter and as agreed to by the Learned Counsel for the parties, comma, this writ petition is disposed of at the motion stage. Full stop, para. It may, however, be noted that the matter was taken up earlier on 28/2/2024 when the Learned Counsel for the respondents were directed to obtain instructions. Full stop, para. The grievance of the petitioner pertains to non-disposal of a mutation proceedings initiated on an application filed by the petitioner. Full stop. Sri Nath in this regard has referred to the letter dated 3/11/2023 of the respondent number 3. Full stop, para. The Learned Counsel for the respondents have, however, submitted that the subject matter involved would fall within the ambit of the Assam Right to Public Services Act 2012. Full stop. It is also submitted that in the meantime, comma, number of petitions have been disposed of by directing the petitioners to take recourse under the said Act of 2012. Full stop, para. This court has noticed, the aforesaid Act of 2012 provides for delivery of notified public service within a stipulated time for matters connected thereto, and mutation is one of the notified service within the meaning of section 2 within bracket I of the Act. Full stop. Section 5 of the Act also stipulates the time frame for disposal of such applications. Full stop. The Act, Section 8 of the Act even provides for an appeal before the appellate authority. Full stop. Para, in this connection, comma, an office memorandum dated 21/12/2020 has also been published by the Revenue Department, laying down the procedure for availing the services, including issuance of demarcation certificate. Full stop, para. In view of the above, comma, the instant petition is disposed of by directing This mutation will come under the Services Act. Under this act. Mainly it was for demarcation. Okay. Directing the petitioner to approach the appropriate authority under the aforesaid Act of 2012 within a period of 15 days from today. And in the event such an application is filed, the same is required to be considered and disposed of within the time stipulated by the said Act and the office memorandum mentioned above.
Plus,
পিছত লাগিব, ন? নালাগে নেকি এইখিনি? Yes.
Maybe the lordship. Lordship, here the petitioner, by the order dated 16/11 of 2019 in MSC case number 86 of 2015 was awarded an amount of rupees 9,12,000 by the MSCT, London MSC Nogam, which is at annexure 1, page 15, lordship.
Yes.
Lordship, relevant portion at page 25. Lordship, paragraph 30, may I read?
Yes. Now what has happened now?
Lordship, presently, Lordship, an amount of rupees 5 lakhs was fixed. That is order dated 16/11/2019, and subsequently on 16/3/2022, on an application, rupees 3 lakhs was withdrawn by her. Was allowed to be withdrawn by her by the learned MSc Nogam. Also presently by the annexure 4 and annexure 5, page 29 and 30. 2 lakhs, rupees 2 lakhs is still fixed. So subsequently she made an application on 13/12/2023 and 18/12/2023 before the learned MSCT Nogam. So for release to release this for direction, we got the said amount of 2 lakh, lordship, but it was rejected.
Let us see the rejection order.
Lordship, at page 31.
3-1.
Yes, lordship. May I read?
You have not annexed any medical
Subsequently,
document.
lordship, she again approached the learned MSc Nogam on 18/12/2023, annexure 7, page 30, lordship. She produced her medical documents, but it was rejected. At
Where
page
is the
32,
medical document?
lordship, at annexure 8, page 33.
Who are the parties here?
Lordship, State of Assam and Judicial Department and Chief Manager, State Bank of India.
Yes, the judicial department is a party. What do you say?
But my lord,
Oh, she is 82 years old.
he is 2 years.
And the observation or the of the tribunal in relation to the document,
Hello.
that appears to be slightly a very kind of a rigid kind of an approach. There are documents, she is 82. FD for 2 lakhs is remaining.
Yes.
After all, the amount, her entitlement to the amount has already been fructified. It has been adjudicated. It's her amount.
Unquestioned.
So not, we'd like to have this day after tomorrow. Just go through, see, issuing notice will only delay the matter. Prima facie, we would like, we might allow this petition. But you just have a, since this is the first day, okay? And issuing notice to State Bank will serve no purpose. They will not have any say. Whether we,
State Bank, my lord,
State Bank
maybe
is a formal party, nothing to do.
we are just a form.
We'd like to have your views day after tomorrow, okay?
Right.
We'll have it day after tomorrow.
Lordship,
Uh,
if you oblige.
On the prayer of Miss S. Sharma, Learned State Council, let this matter be listed on 15/3 to enable her to obtain instructions.
Lordship.
I think.
19. Yes, Mr. Dhor, what is it?
My lord, this is regarding some illegal construction of our in the building premises which is located in Jorhat. My lord, several representations complaints were made before the authorities and
You are the complainant.
I'm the complainant. In fact, I'm aggrieved by the then water filter which has been posted over my roof, illegally constructed.
You're in the same building.
I'm in the same building in the 5th floor, and above the roof on the roof of my apartment. The builder has constructed a roof
Filter.
2 filters in fact.
Yes, who are you?
Well, in fact, I'm from respondent
5 with Jorhat.
Jorhat Municipal Code has passed an order which you'll occupy find at page 66.
66.
66.
Yes, please. Yes.
On 6/7/2022, directing the builder to remove the immediate measures to stop the aforementioned water seepage and leaks so that no harm whatsoever is caused to the premises.
Yes,
of-
thereafter what had happened?
So thereafter, we had a
This
talk-
was in the year 2022.
2022.
Okay.
Thereafter, in January 2023, they have not taken any action. In January 2022, one of the water filter has collapsed because of its poor construction, and
Okay.
thereby damaging the roof of my
Okay.
apartment. And thereafter also, I made several representations before all the respondent authorities.
Hmm.
And a letter was issued on 31, which your lordship will find at page 83.
83.
83.
Yes.
I informed the builder
Yes.
to proper roof treatment and remove the illegal tin shade
Hmm.
which has been constructed for the parking of the vehicles in the building, and that is obstructing the fire removal vehicles as well as the emergency service vehicles in the building.
Yes, then what has happened?
Then this annexure 18, page 90,
90.
90, the deputy director in charge town and country planning requested the chairperson to do the needful regarding the illegal construction carried out by the
Yes.
but nothing has been done till date.
But this is of recent origin, 19 January.
January. Earlier also in 2022, your lordship has seen.
Yes, what do you say?
Lordship, regarding the same, I need to obtain instruction, so kindly.
Heard Sri E. Dhar, learned counsel for the petitioner. Full stop. Para. The petitioner is a resident of a multi-storied building in the name and style Diamond Tower, inverted comma, situated at Jorhat town. Full stop. His grievance is with regard to non-consideration and lack of action by the authorities on the complaints made by him regarding illegal construction by the builder, including construction of water filter over on the roof of the petitioner's apartment, which has caused seepage and damage. Full stop. Though certain communications were issued by the Jorhat Municipal Board, comma, no tangible action has been taken, and accordingly, the instant writ petition has been filed. Full stop. Para. Let notice be issued, returnable by 4 weeks. MED, MSS Sharma, Learned State Council, accepts notice on behalf of respondent 1, 2, 3, 4, and 6. Your name?
S. Bora.
S. Bora. Accepts notice on behalf of the Jorhat Municipal Board, respondent number 5. And what about 7? Jorhat Development Authority. Can you take? You can take perhaps. It's an authority under the act. You can. Okay, let extra copies be served upon the learned counsel for the respondents. Within 2 days, let steps be taken for service of notice upon the remaining respondent numbers 7 and 8 by registered prospectus. Steps within 2 days.
Apply. My lord, this is regarding rejection of my nomination, my lord, for Moregaon Court Bar Association election.
Rejection of nomination.
Yes, my lord. Ultimately, the election has been held, result were declared. and,
How can you come in a writ petition
my lord, when
against an association?
yes, my lord, I'll place 2 judgments, my lord, where actually, in fact, while I was drafting, the same question came to my mind also, my lord. And then I found 2 judgments of one is of Delhi High Court and another is of Karnataka High Court, my lord, which says that Bar Association, which is annexed to the court, my lord, and discharging public functions, they are
Public function, it's a private club. What public function?
my lord, may I submit?
Mr. Chaudhary, Bar Association, do you perform public function? Bar Association, amenability or in a root jurisdiction? We have serious doubts. There are case laws. He says that Bar Association discharges public duties.
My lord, unless it is a registered association.
Even if it's registered, how will a writ be maintainable? You may have a cause of action, not in a writ court.
My lord, if I may.
Will not
place-
extinguish your rights by saying that
If I may
there is no
place,
cause of action. You go before the appropriate authority.
if I may place the judgment and.
Yes, what different high courts?
Uh,
Place
sir.
something else. These are only a persuasive value. Why should you look into it?
My lord, in fact, in
You may
Karnataka,
develop your argument based on that,
in
but
fact,
unless you show some citation, some authority, which is binding, sorry.
My lord, in fact, in Karnataka High Court judgment, my lord, they are referring the Supreme Court bar association case, my lord, which is the page 12, my lord. This says that, my lord, they have distinguished the court annexed bar association with other kind of bar associations or lawyers associations, my lord.
When was this bar association registered? Your bar association?
My lord, as inspected by my friend, my lord, this bar association is not registered.
Sorry. Withdraw this or otherwise we dismiss it.
Then, my lord, I may be given a liberty to approach the appropriate forum.
That will give.
Within a
No,
specific-
no one can extinguish your rights. If you have a right, there is a remedy.
No, my lord, why I am submitting, my lord, regarding liberty, my lord, this.
We'll give you a liberty.
Yes. And,
We cannot extinguish your liberty or right.
And
If you have a right.
delay shall not be.
That is up to you.
No, my lord, why I am
Will
saying,
not get a leverage.
if I may submit, my lord,
No,
why?
no,
why I am
sorry.
submitting,
Sorry.
my lord,
When,
this bar association election, my lord, is governed by a Representation of People's Act, my lord, and there is a limitation of 45 days.
Representation of People's Act.
Yes, my lord, this constitution of the bar association says to, my lord.
Which act? Representation of People's Act?
1950 Representation of People's Act, my lord. I have annexed the constitution of
A
the bar
constitution of a private body says something and he'll place it before the court.
But these
Do you know
days,
the implication
my
of this Representation of People's Act? What is the history of its enactment?
but
And it will
that-
be
that-
applicable to the bar
my lord,
association.
that's how this bar association is running, my lord. The elections are going on. my lord.
Heard.
Yes, that's my lord.
Which is the writer number?
20.
As does learned counsel for the petitioner. Full stop. The grievance sought to be raised in this petition structured under Article 226 of the Constitution of India is with regard to the action of the returning officer of the Morigaon Bar Association in dismissing the appeal of the petitioner wide order dated. Wide order of the petitioner and proceeding to hold the elections. Full stop. In fact, the elections were held on 24/1/2024 and results have been declared, including the post of
Secretary.
the secretary, in which post the petitioner had expressed his interest to contest. Full stop. Para. Even going into the merits of the dispute, this court is of the opinion that the powers exercised by this court under Article 226 is an extraordinary power whereby prerogative writs can be issued and private disputes of the present nature cannot be raised or is entertainable in a writ petition. Full stop. This court has also been informed that the Morigaon Bar Association is not a registered association. Full stop. In any case, registration of a private association itself would not make it amenable to the writ jurisdiction of this court. Full stop. Para. Accordingly, the instant petition is held to be not maintainable and dismissed. Full stop. The petitioner, however, is at liberty to approach the appropriate forum for redressal of his grievance in accordance with law.
So within a time frame of 10 days, because that will, otherwise, then the question will come regarding 45 days of.
It's up to you. Decide. Why should we give you undue leverage? Sorry.
This petition has been prepared within the 45 days.
Will not say that. Yes, next.
May I please the lord.
Yes.
But our grievance in this case, my lord, regarding non-registration of FIR, my lord,
filed by the petitioners, my lord.
Yes. You are the ex-president.
Lordship.
You want to be again a president.
We have filed, my lord, FIR, my lord, regarding, my lord, taking bribe and manipulation of documents. And
Not maintainable. It appears to be a very myopic issue, fight between you and the ex-president and the present president.
the SP,
And you have gone to the extent of lodging an FIR. You fight it out. Why do you want the Reed Court's assistance?
not only, my lord, a police may, my lord,
Not maintainable. Sakiri Basu.
we are not against, my lord, inaction of police, my lord.
There-
Non-registration of case.
Even non-registration is a part.
of process.
Non-registration, no proper investigation. Heard Sri R. Ali, learned counsel for the petitioner, also heard.
But
Also
Our case,
heard.
my lord, covered, my lord, Lolita Kumari's, my lord, job.
Lolita Kumari, okay. You know what to do if it's not registered. You write to the SP,
Yes,
then Lolita
we
Kumari will
filed
come.
before SP forwarded to OC.
Heard Sri R. Ali, learned counsel for the petitioner. Full stop, also heard.
I'm
Miss
from 1, 2,
M.
4 and 5.
M. Burman, the learned state council, as well as
B Deca for response number
BDECA for the respond number for the which department?
education.
Education elementary.
Dot.
Education elementary department, full stop para.
Okay.
Considering the subject matter
Yes, sir.
and subject matter, comma, the writ petition is taken up for disposal at the motion stage, full stop. Para. The petitioner claims to be an inhabitant of the district of Hujai under the jurisdiction of the Murajhar police station, full stop. He also claims to be a guardian of a student of Sunai Bibi LP school, full stop. The president is the petitioner is the ex-president of the school managing committee within bracket SMC of the said school, full stop. The grievance of the petitioner is, no, it is the contention of the petitioner that a new school managing committee was constituted on 17/10/2023 without following the due procedure. And the petitioner was not even aware of such constitution, full stop. The petitioner has also alleged gross irregularities and illegalities committed by the new committee, in which regard, comma, he has lodged an FIR, an Azahar on which date?
14/12, my lord.
14/12/2023. Full stop. The grievance of the petitioner that no action has been taken on the said FIR, full stop. Para. Miss Burman, the learned state council, as well as Ms. Deca, the learned standing council, education department, have, however, resisted the case by contending that issues regarding inaction of the police, comma, non-registration and delay and lack of proper investigation would not come within the ambit of a writ court unless and until an exceptional case is made out, full stop. Reference has been made to the case of the Honorable Supreme Court reported in so-and-so Sakira Basu versus State of UPSL, नहीं ना बिहार से UP, full stop, para. The Honorable Supreme Court in the said case has discouraged entertaining of writ petitions pertaining to issues of non-registration of FIRs as well as lack of proper investigation, as the CRPC is a self-contained code giving remedies in such eventualities, full stop. This court has also noticed that no exceptional case has been made out which may require intervention of a writ court, full stop, para. In view of the above, comma, the writ petition is held to be devoid of any merits and accordingly dismissed.
Okay.
We may even liberty to oppose my lord the concern, my lord, that otherwise.
That is up to you. Yes, next.
May I please? In this case, your lordship, on 02/05/2022, at 9 p.m., your lordship, the husband of the petitioner had expired in a road traffic accident in public place. And after the untoward incident, your lordship, petitioner filed an application on 10/08/2023, taking a compensation as
You're praying for ex gratia.
Yes, Lord.
We'll issue notice at this stage.
Lordship,
One thing, if I may most humbly draw your lordship's attention to page 23 of your lordship's brief.
2-3.
Yes, there, the petitioner has not approached the deputy commissioner with the next of kin. So
Okay.
if he approaches the deputy commissioner with the next of kin, it will be
Where is your
considered.
next of kin?
at page 21, your
He has annexed it here, but he has not placed it before the deputy commissioner. Let him go and place it before the deputy commissioner. He'll consider for that.
See, madam is absolutely correct.
Lord.
Your next of kin is dated 24. It's a recent origin, 22nd of February.
Yes.
Your application to the deputy commissioner is August 2023.
Lordship. But at least deputy commissioner may give any notice to for submitting the NOK. That is, but deputy commissioner nothing to do in respect of this.
No, his
writ
charter, my lord, clearly lays out, my lord. Page 24 is his charter, my lord, that lays out.
Lordship.
Heard Sri S.I. Akand, learned counsel for the petitioner who has approached this court for release of ex gratia payment for the deaths of her husband, who has been stated to have met with a road traffic accident on 3/5/2022. Full stop. Para. Let notice be issued. Returnable by 4 weeks. Miss G. Hazarika, Learned Standing Council Revenue Department, accepts notice on behalf of response number 1. What about Finance Department? Finance. H. Barua. Then it's council appearing on instruction of 3 B. Gogoi, Standing Council Finance, for response number 2. 3, 4, and 5,
Well,
Madam
I-
Secretary. 3 and 4 and 5 by MS S. Sharma, London State Council, full stop. Para. Let extra copies, huh? By tomorrow. Para. Miss Sharma, the London State Council, however, has pointed out that the application before the before the district commissioner, Golaghat, is not accompanied by the next of kin certificates, as apparently the said certificate has been procured on 22/2/2024, whereas the application was submitted on 10/8/2023. Full stop. Para. Pendency of this writ petition shall not be a bar for the petitioner to resubmit the application along with the next of kin certificate.
Lordship, accident took place on 2, Lordship, not 3.
He died on 3/5.
Oh, Lordship.
Yes.
May I please, your lord. My lord, in connection with the construction of the flyover at Tezpur Mission Charali,
I was served with a notice, my lord, by the department, that I have to give up my 52 feet of land from my own house. They said page, my lord, 39 is the version, Assamese version, my lord. Page 38 is English for translation copy, my lord. My lord, again, I approached the court earlier, my lord, that without giving
Your
me
application has not been considered till
nothing,
now.
nothing.
Yes, yes, what is this?
My lord, in a similar case, your lordship has given protection. I have annexed the order also. And all the cases have been fixed on 9/4 for finally disposal.
Yes, who was appearing in the earlier cases?
My lord,
Madam Hazarika? National Law has been made a party.
yes, yes.
Names are appearing. Who is NHAI? C. Barua or R.K. Talukdar? Can you get hold of them? We'll pass orders fixing on 9/4 and give you some interim protection if in the other cases such protection is
Yes,
granted.
I-
Try to have them. Mr. Gupta, what is this?
My lord, a land acquisition process was initiated against the private respondents on the pretext of the SSB authorities, my lord. A land acquisition process was initiated, but that process, after the initiation of the process, my lord, the government of Assam, my lord, requisitioned the land under the Assam, my lord, the Land Requisition and Acquisition Act 1964.
64. Oh.
My lord, after the requisitioning of the land acquisition process that lapsed, my lord, the SSB authorities said that, my lord, the land is not further required.
Okay.
My lord, subsequently, my lord, the private respondents herein, my lord, preferred a writ petition, my lord, claiming requisition compensation for the period during which the land was kept under requisition. My lord, the petitioner filed a writ petition. My lord, page 29 is the direction of the writ petition, wherein, my lord, it was directed that the deputy commissioner, my lord, last paragraph, page 29, in view of the above and as agreed to by the learned counsel for both sides, I dispose of the writ petitions by directing respondent number 3, that is the deputy commissioner Kamrup Rural, to consider the grievance of the petitioners and thereafter take appropriate steps for handing back the possession of the land to the petitioner and also paying for requisition compensation to the petitioner for the period during which the land remained under occupation of the respondent authorities. In doing so, it will not be only open to the respondent number 3 to make fresh assessment of the amount of compensation that is to be paid to the petitioner, but he would also be entitled to take a decision as to whether the land in question falls in the category of agricultural land or the same is a petit land. That is the wasteland, my lord. The exercise is directed to be completed within 6 months. So, my lord, therefore, the direction was given to the deputy commissioner to determine whether the petitioners would be entitled to requisition compensation or not. My lord, thereafter,
what has happened now?
my lord, thereafter, my lord, at page 33, the
Yes.
deputy commissioner, my lord, issued a letter to the SSB authorities in order to, my lord, come to a finding as to the determination of requisition compensation. My lord, last two paragraphs, my lord, will be page 33.
33.
33, my lord.
Yes.
Further,
Yes.
my lord, this is addressed to the SSB authorities by the deputy commissioner pursuant to the quotation last second last paragraph, my lord. Further, although the above order of the Honorable High Court to pay compensation to the Pattadars, it is not clear how to calculate requisition compensation or what is the basis of arriving at a requisition compensation or what are the components of requisition compensation.
Yes.
In this connection, an opinion regarding calculation of requisition amount asked by this office from the Advocate General to the Government of Assam, Guwahati High Court and represented counsel. In this regard, a letter is received from Shri Devajit Tikya, Senior Advocate General Assam, where it is mentioned that after receiving the actual position about the status of the land, regarding calculation of requisition amount will be intimated. Therefore, you are requested to submit a report about the actual position of the land at an early date. Now, my lord, thereafter, at page 34, we have replied to the letter.
Okay.
Page 34, my lord, annexure 4 is the reply. And my lord, page 35, I will take my lord to the relevant portion, last two paragraph.
What is your grievance now?
My lord, the grievance is that my lord, the deputy commissioner has assessed the requisition compensation contrary to the provisions of the 1964 Act. Because the land was never, my lord, taken into possession. The physical possession of the land was not taken from the private respondents, my lord. And when the physical possession is not taken, my lord, the only remedy is, my lord, that the land would be returned back to them. So, my lord, the determination of the requisition compensation is prima facie contrary because, my lord, the SSB authorities have never taken the possession of the land.
What document do you have to
My lord,
substantiate? Otherwise,
my-
these are factual matters.
No,
Do you have any documents to
my lord,
substantiate
there is
that?
a, my lord, during the pendency of the writ petition, my lord, at page, my lord, 48, my lord, page 48.
48.
Page 48, my lord, second paragraph, there is a finding, the clear finding that the land was never surrendered by the private respondent. my lord.
Where?
Paragraph 48, my lord, second paragraph.
Yes.
However, well, during the pendency, original records were produced, my lord,
Yes.
in the earlier round of litigation. However, on perusal of the records in original place before the court, it is seen that neither the records of the LA case 6 of 2019 nor of LA case 7 of 19 contain any such surrender of land by concerned Patadar, including the petitioners, after the issuance of such notice in Form C under Section 4(1) of the said Act. Moreover, the report of the concerned Latmandal also reflects that the said land acquired are fellow petite land and not agricultural. Therefore, my lord, in view of the categorical finding that the land were the possession, physical possession was never taken by the SSB authorities, my lord, the award of the direction by the deputy commissioner directing to pay requisition compensation is, my lord,
But the order by which the compensation has been assessed, that is first of, it is firstly is of June 2023.
My lord.
Number one.
My lord.
You have not explained your delay. Number two, it has been passed pursuant to a direction of this court.
Yes, direction was to, my lord, make the assessment. And during the process of assessment, my lord, we have clarified to the authorities at page 35, my lord, last paragraph, which was earlier I was referring.
Sri H. Gupta, Learned Counsel, Learned CGC, appearing for the petitioners, full stop. The petitioners have put to challenge an order dated 8/6/2023 passed by the, I think it's the District Commissioner nowadays, District Commissioner, Kamrup, whereby requisition compensation has been estimated regarding a process of acquisition oblique deacquisition of a plot of land from the private respondents. Full stop. By referring to the earlier proceedings before this court, comma, the learned CGC has submitted that there are materials to show that though the land in question was requisitioned, comma, possession of the same was never taken over from the Patadars, and the said issue and other related issues have not been taken into proper perspective while making the impugned estimate. Full stop para. Let notice be issued, returnable by 4 weeks. Ms. G. Hazarika, Revenue. Learned State Standing Council Revenue Department accepts notice on behalf of respondent 1 and 2.
3, 4, 5, and 6.
Whereas MS S. Sharma, the State Council, for respondent 3, 4, 5, and 6. Extra copies by tomorrow. Steps for service of notice upon the respondent 7, TO2, 14, 15 be taken by registered post with AD. Steps within 3 days.
All right.
Wait, your lordship. One of the petitioner of your lordship, he was president of a Gram Panchayat and his term is over on 2nd of March 2024. There is some inquiry being conducted against utilization of certain funds. It may take your lordship to page 62. This is a communication issued by the Chief Executive Officer of the Jilla Parishad.
When did your term
My
expire?
term is over on 2/3/2024, 2nd of March. But this communication is prior to that, 21/2/2024.
21/2,
Yes.
page
62.
62.
I am not against the inquiry, my lord.
62, yes.
Now, this has been addressed by the Chief Executive Officer of the Jilla Parishad to the Deputy CEO, Executive Engineer, and BDO. May I read it, my lord? Regarding inquiry on verbal complaint raised by Honorable MLA Kurukhetri LSC. With reference to the subject cited above, I'd like to inform you that as per verbal complaint raised by Honorable MLA Kurukhetri LSC regarding implementation of the 14th FC grant interest fund has been utilized without prior approval.
No, this we have read. Then what is your grievance?
My grievance is that, my lord, you conduct an inquiry. I have no problem with that. But in the name of the inquiry, this respondent number 7 and 8, they are demanding money from me. I made a statement, my lord.
Who are 7 and 8?
There 7 and 8 have been named in this order. At page 62, your lordship was reading, my lord. In this regard, the following officials are hereby entrusted to assist.
Why don't you lodge an FIR?
My lord,
Lodge an FIR.
I am apprehending that a FIR may be lodged against me, my lord.
No, if they are making illegal demands, lodge an FIR. Where is your statement?
My lord, paragraph 12 at page 12. Also in paragraph 13 and 14. That the petitioner begs to state that by communication that is so and so, though the Chief Executive Officer Proper Jilla Parishad requested the respondent number 456 to make a joint inquiry into the matter regarding utilization of the interest fund by the Paschim Pakka GP, but the respondent number 456, in spite of initiating an inquiry, has been pressurizing and harassing the petitioner through the respondent number 7 and 8 by demanding
immediate refund of interest fund. That is not demand of money.
Interest fund, my lord, either to them personally or to the Jilla Parishad. The question doesn't arise, my lord. That's why I am ready to face the inquiry. But why this harassment? Let them
You don't pay.
Some observation your lordship will make, my lord, or maybe I'll lodge an affair against them.
Lord, the petitioner is at liberty to do anything against the people who are harassing him. There's nothing PNRT can.
Will not make any observation.
Your lordship will restrain them from, my lord, the coercing
Can
me.
we restrain somebody from doing something illegal?
From coercing me, my lord. Coercing me to make payment. I have also written
Difficult.
two
Okay.
paragraphs.
Heard Sri M.K. Chaudhary, Learned Senior Counsel for the petition assisted by Sri H.S. Sigdar. Full stop. The facts projected is that the petitioner was elected as the president of number 44 Paschim Pakka Gaon Panchayat in the district of Barpeta in the year 2018, and his tenure is complete on 2/3/2024. Full stop. After during the subsistence of his while he was holding the said office, an inquiry was initiated by the communication dated 21/2/2024, whereby the respondent numbers
4, 5, and 6 have been directed to conduct the inquiry.
not two respondents.
7 and 8.
Respondent numbers 7 and 8 have been directed to assist
The respondent number 4, 5, and 6.
assist the inquiry, assist in the inquiry.
Yes, fine.
Full stop. Para, by drawing the attention of this court to the averments made in paragraph 12 of the writ petition, comma, it has been contended that even without the inquiry being complete, comma, there is illegal demand, mainly from the respond numbers
7 and 8.
7 and 8. पहले 7 and 8 लिखा था ना अभी 7 and 8 for refund of the interest fund of the 14th FC grant, page 12, paragraph 12 से देख लीजिए, of the said panchayat to them personally or to the Zilla Parishad, full stop. It is contended that such demand is wholly illegal and amounts to harassment. Full stop. Let notice be issued, returnable by 4 weeks. 3. Hendik.
Lord, I'm for 1 to 5 only, ma'am.
You are
7 and 8
A Hendik.
P hand.
P Hendik. Sri P Hendik, Learned Council, representing the Panchayat and Rural Development Department, accepts notice on behalf of respond numbers
1
to 5.
1 to 5.
Let extra copies be served upon him by tomorrow.
Well.
Let steps be taken for service of notice upon the respondent number 6, 7, and 8 be taken by registered post with AD. Steps within 3 days. Full stop. With regard to the prayer for interim order, comma, it is provided that the respondent authorities would ensure that the enquiry is held strictly in accordance with law.
Without harassing deputies.
Strictly in accordance with law.
Obliged.
For you, court was waiting.
No, that's not that way.
There's some matters pending on 9-4.
9
Okay, here the case is, my lord. Lordship, I have done for job, your lordship. Annexure 4. Here it has been said that we are going to acquire it. No, it is not in Assamese version, your lordship will say. They are illegally, they are occupying our road. That is why it is অবগত করা হয়েছে যে আপনাদেরকে খালি করে দিও আমি ফ্লাইওভার বানাবো। That is the content in Assamese.
No.
But he is telling, he's in English version, it is telling that we are going to acquire. No, it is our land.
It is not your land. That is the crux of the whole matter.
That is
52 feet from the middle of the
that-
road,
that-
they wanted to forcefully occupy and to demolish my building. That's why, my lord, in a similar situated other
Lordship,
petitioner also have come, my lord, before your lordship.
Lordship only,
Yes.
kindly, because real pictures should come. We do not want their land without entertaining any provision, without payment, nothing. The payment will be paid. But here the case is there, your lordship may pay to
Yes,
39.
have produced.
1-3.
Huh?
1-3.
39,
39.
39. And that's the 4 in Assamese.
ইয়াৰ দ্বাৰা ৰাইজক জনোৱা হয় যে তেজপুৰ মিছন চাৰিআলিত উৰণীয়া সেতু নিৰ্মাণৰ বাবে অচিৰেই দুয়োকাষে ৰাষ্ট্ৰীয় ঘাইপথ বহলোৱাৰ কাম লোক নিৰ্মাণ ৰাষ্ট্ৰীয় ঘাইপথ বিভাগে হাতত ল'ব। বৰ্তমান উক্ত অঞ্চলৰ ৰাষ্ট্ৰীয় ঘাইপথ দুয়োকাষৰ ঘাইপথৰ বাবে সংৰক্ষিত ভূমিত কিছু লোকে বেদখল কৰি অবৈধভাৱে গৃহ ইত্যাদি নিৰ্মাণ কৰি ব্যৱসায় বা অন্যান্য কামত ব্যৱহাৰ কৰি থকা পৰিলক্ষিত হৈছে। সেয়েহে উক্ত বেদখলকাৰীজনক এই জাননী জাৰি কৰাৰ এসপ্তাহৰ ভিতৰত পৰুৱা চাৰিআলিৰ পৰা বালিপুখুৰী বিপি তিনিআলি পৰ্যন্ত ৰাষ্ট্ৰীয় ঘাইপথ আৰু ৰাষ্ট্ৰীয় ঘাইপথৰ বাবে সংৰক্ষিত দুয়োকাষৰ মাটিৰ পৰা সকলো ধৰণৰ বেদখলমুক্ত কৰিব অৱগত কৰা হ'ল। ইয়াৰ সময়ৰ ভিতৰত পুনৰ দিনতে উক্ত অঞ্চলত বিধিসন্মতভাৱে উচ্ছেদ অভিযান চলোৱা হ'ব আৰু উচ্ছেদৰ সময়ত হোৱা বেদখলকাৰীখনৰ ক্ষয় ক্ষতিৰ বাবে কোনো ধৰণৰ ক্ষতিপূৰণ দিয়া নহ'ব। Against this, my lord, I have approached the honorable court. This is my patta land, and I have made it. Honorable court has disposed my representation. That is my page 41. That you filed a representation to the deputy commissioner. That also I have done. He remained silent last 1 year.
My lord, one thing is that when we go
Oh,
for
okay,
acquisition of
just tell
land,
this to me.
there is a procedure. But my learned friend is telling that under 64, no, 1964 it will not. It will be because as national highway, it will come under, and national highway 1956, it will not come under 1964 Act. It is 56 Act will follow.
No, no,
And-
Mr. Borua, we are on a different footing. He has also referred to the earlier round of litigation.
Yes, one
wherein
representation.
his contention has been recorded. We are not saying these are findings
Okay.
of the court.
We'll dispose of it.
But he says that this court has recorded his submission that he is the owner in possession of 1 bigha, 1 katha, covered by DAG number so-and-so, PP number so-and-so.
Yes.
Yes.
If this land is not within the ambit of the land which is under the notice, which has been given to persons who have encroached upon the land, matter would be taken in a different perspective.
Yes, that-
But
that-
why don't you
We'll dispose of representation. Whatever representation, we'll dispose of.
dispose this?
I'll get, today itself, I'll guide within 4 weeks, we'll dispose of.
Let it
Oh.
on 9/4, let final order may pass.
We have it on 9/4.
Oh, that is, of course, that is to DC, not to me. That is to
DC, yes,
DC.
Deputy Commissioner.
Deputy Commissioner.
Deputy
dispose of-
Commissioner.
Maybe you have already disposed of. We don't know.
No, nothing has been done. We have approached many times.
Okay. Hard. We'll fix on 9/4. In the meantime, you take steps. Hard Sri S.C. Biswas Learned Counsel for the petitioner. Full stop. It is the case of the petitioner that earlier he had approached this court by means of WPC 7136 of 2022 pertaining to a notice dated 1/7/2022. Full stop. Though the notice was in the context of directing encroachers to remove all encroachment so as to facilitate the construction
Flyover.
the flyover at Porua Chariali, Tejpur, comma, the projection of
by
the
that is
petition by
NHL.
NHAI,
No,
comma,
that is
the-
not NHA, that is National Highway, Lukome, Nepal, that is PW.
Yes, I have
Here
written.
it is Lukome.
I made
by-
PWD
by
part.
Matu here. It is the case of the petitioner that the land concerned is a patta land. Full stop. By referring to the earlier order dated 11/11/2022 passed in the aforesaid WPC 7136 of 2022, comma, it is submitted that a direction was issued by this court for consideration of the representation, which till now have not been done. Full stop. It is the case of the petitioner that without disposing of the representation, comma, steps are being taken to forcibly evict the petitioner and demolish his
Building.
house.
House and building.
Full stop, para. Sri Biswas, the learned counsel, has also informed that there are certain similar matters which are coming up for consideration, which are slated to be listed as LATED, slated to be listed on 9/4/2024. Full stop, para. Let notice be issued. No, don't say. List this matter on 9/4/2024 along with WPC
4596 to 2022 and 4596
4596 of 2022.
and
Full stop.
4597 2022.
Pendency shall not be a bar for the competent authority, namely the Deputy Commissioner, Sonitpur, to consider and dispose of the representation pursuant to the earlier order of this court, if not already disposed of. Full stop. Ms. S. Sharma, the Learned State Council, may accordingly obtain necessary instructions in this regard.
Well, till then, no coercive action will be taken.
Um, It is provided that till the next date, comma, status quo as on today be maintained. Full stop. It is however made clear that since this order has been passed without affording the respondents opportunity to have the instructions, comma, the same will be reconsidered. on the next date. नाम लिख दीजिए N Borderloy Revenue 1, C Barua NHAI, H Barua 4, B Gogoi 4 and 5, S Sharma State Council 2 and 3.
Well, extra copies have to be
Extra copies, please give. Let extra copies. Huh?
May I please, Your Lordship? In this case, Your Lordship, we have challenged the rejection of our technical bid, Your Lordship, which was initially accepted, Your Lordship, and then Your Lordship, subsequent LOA issued.
But before my matter start, note that we have made parties to file a caveat, the matter. So respondent number 5. So till let the copy be start, matter will be taken up Friday, Lord.
Monday, Your Lord.
Can it be on
Monday, my lord, Monday, my lord, I'll be not there. Can it be on then Tuesday, my lord?
Tuesday, is it okay? Tuesday?
Lord.
Okay. At the heard 3 as Botakur Learned Counsel for the petitioner, full stop para. 3 K Agarwal, Learned Senior Counsel, assisted by Sri M. Das. Learned Counsel, however, submits that so far as the respondent number 5 is concerned, a caveat has been lodged. Full stop para. Let the said caveat be listed for consideration. Full stop. Let a copy of the petition be served upon Sri Das, and the matter be listed on and on request. Let this writ petition be listed for motion on
Tuesday.
Tuesday will be
19.
19th.
Okay.
Deeply obliged.
कोई confusion तो नहीं है ना? Yes.
And the order dated 25/9/23 may can be distributed.
Matter not settled.
25 September.
Not yet settled.
They are not opening the lock of the inside the office. And the DC has admitted.
Outside it is open.
Are open. And the DC has admitted that the meeting has been held. And but the
Yes,
lock is not open inside.
Who are you? Which order?
My lordship, peruse the order dated 25/9/23. Last paragraph.
25/9.
23, yes.
Oh yes, GAP.
Last part 1. Yes.
25/9. Please give him a copy to Mr.
My lord, kindly see in view of the above.
Which order?
My lord, 25th, my lord, 25th September.
Yes, that we have.
Last, in view of the above, the Principal Secretary to the Government of Assam, GAD is hereby directed to conduct an inquiry in terms of the earlier order that is so and so passed by this court and thereafter submit a report.
Yes.
The aforesaid authority may issue notice to the rival parties. They have issued the notice. We have appeared.
Yes,
But
we
the
appeared,
report-
my lord. Both the
but the
parties
report
appeared
is-
there, my lord.
But the report is not submitted by the
That is
Principal
what.
Secretary.
That is what left out.
Get the report. Get the report. Okay. I heard Sri R.C. Saikia, Learned Counsel for the petitioner. Also heard Sri M. Nath, Learned Senior Counsel, assisted by Madam, your name? DL Decker. DL Decker for the respond number
6 to 16.
6 to 16.
Yes, sir.
Full stop. Para. Three. The three Saikia, the Learned Counsel for the petitioners by referring to the order dated 25/9/2023 has submitted that a direction was issued to the Principal Secretary, GAD, Assam, to cause an inquiry. Full stop. This court has also seen that the Standing Council GAD was to be given an opportunity of hearing full stop para. 3. A. Fukan, the Learned Standing Council GAD, however, submits that copy of the writ petition have not been served upon him, and therefore he is not equipped with the latest instructions with regard to the enquiry directed to be caused by this court, full stop para. Let an extra copy of the writ petition be served upon Sri Fukan by tomorrow. When can we leave? We'll have it on next Friday. List this case on 22nd of March 2024, on which date Sri Fukan, the Learned Standing Council, will place before this court the necessary instructions towards compliance of the earlier direction requiring an enquiry to be conducted, requiring conducting of an enquiry. Full stop. Let the name of Sri A. Fukan, Standing Council GAD, be reflected in the cause list.
My lord, can you do 20 or 21st, my lord? Any
Any date, any date.
20th,
we
my
wish.
lord. Make it on 20.
20. 20 is it? 20 will be okay for you? Today is what?
21st, will have it.
21st. 21st also make it.
21st.
21st.
He'll have 1 week's time.
Yes. Obliged.
Para. You get a copy of this. You get online nowadays. No
We will give it right now.
no, not of the writ petition. You in the order.
We'll give my learned friend.
Obliged.
Yeah, what the we just know.
Thank you.
Mr. Chaudhary has come. Wait, I got it.
Sorry,
No, doesn't matter. On the next date of listing, petitioners shall apprise on the point who is the authority competent to remove an MLA from his office as per 17A of the Prevention of Corruption Act. So far as prosecution sanction is concerned.
Yes, yes.
My lord, there's another facet to it. Lord. The lordship would kindly have a look at order dated My lord, 13/12/23.
13/12. Yes, please.
In this view of the matter, Lordship, can I read it, my lord? Para 2. The prayer number on the writ petition is as follows. A writ in the form of mandamus or any other writ as deemed fit by the Honorable Court shall not issue, thereby directing the respondent authorities, specifically respondent number 2, to take into consideration the approval request for initiation of a criminal case against the suspect officer Dulab Mohanrao, as sought by the Superintendent of Police, Directorate of Civil Vigilance and Anti-Corruption Assam by the Secretary. So, and after perusal of the same, grant immediate appropriate government approval or rejection as the case may be, after examining the same as per the mandate of law to enable the enforcement agencies to further case. The writ petition was filed on 14/3/23. A copy of the order dated passed by the Secretary to the Government of Assam Home and Political Department has been placed on behalf of the petitioner. As per the said order, competent authority has not granted approval to initiate criminal prosecution against the respondent. So, my lord, this is the position. And this is
You
the
are for
order.
R5.
Yes.
You are for R5. There is
Yes.
no sanction for
No
prosecution.
sanction, but in that view. of
Is
the
there any
matter-
order for rejection of the sanction?
Yes, yes, my lord, it was placed on record. I can give one copy.
Is it 10th of June?
10th of June, my lord. So in view of this, perhaps, my lord, they'll have to challenge it, my lord.
This order, if you are aggrieved, you have to challenge this.
Yes.
My lord, before starting my submission, what is the matter? The matter is disproportionate assets of respondent number 5. My complaint, annexure 1, dated 27/11/2018.
Page?
Is page number 21.
21, yes.
The subject is complaint toward large-scale misappropriation of government funds and properties disproportionate of income by Dr. Dullab Samoa, ex-MLA Nagaon.
Okay.
Lordship, on the basis of this, an approval was granted by the government. And the order is placed on page number 24.
24.
24.
Yes, please.
On the basis of this order, an inquiry was initiated. During the process of inquiry, the competent police officer found that 2,16,05,994 rupees 46 paisa is the disproportionate assets. And they had written a letter to the Secretary to Government of Assam. This letter was written when the writ petition filed by petitioner number 1 before this court, and a notice was issued on
Which is that letter?
page number 25.
Next page. 25, 13, 1, 21. What does he write?
Yes, sir.
What does he write, the Superintendent of Police? He writes to the Secretary.
He writes to the Secretary to the Government of Assam.
Yes.
Prima facie, this letter is bad in law. Because in the matter of PV Narasimha Rao versus state.
By this letter, what did he seek for?
They are seeking for permission for registration of criminal case under section 13(1)(b) and 13(2) of PC Act.
Yes. The law. Yes.
As per the judgment of PV Narasimha Rao matter in the Supreme Court, the competent authority who can remove a MLA is the Speaker of the Legislative Assembly for the purpose of Prevention of Corruption Act. This is a settled case.
Yes.
When, if any requirement of any approval or sanction is there for the purpose of PC Act against a MLA or a former MLA, the competent authority is the Speaker of the Legislative Assembly.
Yes.
Here the permission has been sought from the Secretary to the Government of Assam. So prima facie, the letter dated 13/1/2021 is a bad in law. Now I will come the background of this letter, Lordship. I have already submitted an affidavit in detail against the government order. In this, I have clearly mentioned, Lordship, one notice issued by this court to respondent number 1 of the present case, respondent number 4 of the present case, and respondent number 5 of the present case, where the allegation are the vigilance officer are doing some malpractices in giving safeguard to the respondent number 5.
Where are the notices?
Page number 132.
132.
Yes, sir.
Yes.
So on 6th January, this court issued a notice. And what happened on the very next day, in the Office of Vigilance and Anti-Corruption, they put up a draft letter, which may kindly be seen at page number 136. That is the translation copy of the official file note sheet.
What was the subject matter in this?
Same subject matter, this
WPC
letter.
5332 of 2020 at 132.
That was there. I have filed a complaint against Vigilance and Anti-Corruption. Almost 2 years has been passed. Despite regular follow-ups and everything, vigilance officers are not taking due action, despite they have the concrete information that disproportionate assets has been there, and the report of the chartered accountant was there. Verbally, they have informed that the chartered accountant informed that this and this amount of disproportionate asset has been there, and that has been found out of the findings of the income tax returns and the reports collected from the circle officers. Reports, the reply submitted.
Where is the draft? You have said there is a draft prepared after a notice.
This is the letter dated 13, page number 25 letter was drafted on 7th January 2021. Just after this court has issued the notice.
Yes.
Means on that day, Vigilance and Anti-Corruption has clear information that 2 crore 16 lakh. Means the ground is that their findings are there. They entered into a quid pro quo relationship or understanding with the respondent number 5 and put the file under the red carpet. Suddenly and surprisingly, one notice of this High Court has been issued, and they found nothing and prepared one letter and sent it to the government of Assam, which is not the competent authority. But most surprisingly, Central Bureau of Investigation registering hundreds of FIRs every year without obtaining any approval from any authority whatsoever or whomsoever under Section 17A of Prevention of Corruption for disproportionate asset cases. This is a central legislation. Why a FIR has not been registered by the Vigilance and Anti-Corruption is the prime matter of concern, whether the police officer is duty bound to register a criminal case when he has knowledge of the cognizable offense has been there. The sections in which they have sought the approval, 4 years to 10 years of the imprisonment. So this is a very big scandal. We may call it a vigilance scandal. How the corruptions of the MLAs, MPs, ministers has been covered up. And this political system nowadays, everybody knows how the government and higher authorities, how the police officer harass the petitioners and everything to somehow or some way cover up the entire scandal. This letter is bad in law. There is absolutely no requirement of any approval or any permission from any authority for registration of FIR. This is a settled one. And the CBI case of Devendra Kumar versus CBI matter.
Just a minute. Prevention of Corruption Act concern. Prevention of Corruption Act. Get an idea there. Direct. P. What is your ultimate prayer?
My
your
first prayer.
your
is-
Bucha.
Yes, my.
Let us see. There is a distinction between section 19 and 17A.
Yes, exactly, sir. I am submitting it.
19
Neither
says
section 19 is applied nor section 17A is applied. I am submitting its lordship. The R.S. Nayak versus A.R. Antule judgment specifically said once you have removed this office on which you have supposed to done the crime, there is no requirement of
Antule, which one are you referring to? There are 3-4 judgments.
Yes, my lord. Section sanction for prosecution of a person alleged to have committed offense in the capacity of chief minister held not required where cognizance of such offences taken after he had already ceased to hold the office of chief minister, thou still a sitting MLA not a public servant. However, after the Amendment Act of 1988, MLA and MP have become the public servant for the purpose of Prevention of Corruption Act.
Correct.
But relying on this judgment, hundreds of judgments are there. Prakash Singh Badal is there.
Yes.
Abhay Chotala is there. K. Karunakaran is there. Many judgments are there, Lordship. And repeatedly, Honorable Supreme Court has said, once he has been reformed, actually, what is the basic intent? That an honest person should not be harassed. But that should not be there that in the name of harassment, a corrupt person will be left out scot-free. Here, there is a clear-cut case of quid pro quo between the agency, the government officials, and the person against whom the allegations have been there.
So, are you contending that there is no requirement of a
There is
sanction?
no requirement of approval, Lordship, under section 17A for registration of FIR for this 2 crore 16 lakhs rupees. This has been there. And after
No,
registration,
read 17A of the PC Act. This came in later in 2018.
2018, sir. Section 17A is reads, no police officer shall conduct any inquiry or investigation into any offence alleged to have been committed by a public servant under this act where the alleged offence is relatable to any recommendation made or decision taken by such public servant.
Yes.
Next is who is the competent. But what is the public duty or official duty in regards to disproportionate assets? An MLA purchased a property in the name of his minor daughter. 100% payment is made in cash. that has been found by the income tax department. When the income tax department inquired into the matter,
See, there has to be an adjudication process by the competent authority, either declining or approving. And that can be the subject matter of challenge. You are now, what you are contending can maybe correct.
Lordship 17A, because this, I have a judgment of Madurai Bench of Madras High Court. This is the same disproportionate asset cases. And the court says, I am of the view that prior approval under section 17A of Prevention of Corruption Act is not at all necessary, and that the said provision is not applicable to the disproportionate asset cases.
That is the allegation which you are
No,
making.
no, allegation is not, the judgment is there. Court has dismissed the.
Butchart, have the patience to listen to the court.
Okay, my lord, I'm sorry.
You are appearing in person, you are giving you certain extra liberty. Don't misuse your liberty.
I apologize.
Your tone is not palatable. You don't have to shout in the court.
No, I'm not.
We are not short of hearing.
No.
From the beginning, you are shouting. We have not said anything. Only because you are appearing in person. Doesn't mean that you will get an additional leverage in this court.
No, my lord. No, I
Don't even
sincerely
expect this in this court. You don't have the patience to hear, that listen to the, what is the question or the query of the court. We have been hearing you patiently. There is no disturbance by the senior counsel. But this is not the tone you employ in a court.
I apologize.
We have asked that this is your allegation of disproportionate assets. Your allegations may be 100% correct. There may be substance and materials to prove this. But there has to be an adjudication process, maybe by an authority who is competent in law, either to say yes or no. See, 17A, you must have read hundreds of times. 19 and 17A, there is a vast difference. 19 talks about the prosecution sanction. 17A talks about even an investigation. And this letter which has been put on record, you may be correct in contending that this letter has not come from the appropriate authority. It may be the speaker, but here it has come from the political department, which may not be the correct authority. That's another facet which we may look into. But unless your allegations are first looked into and an order passed, which can be the subject matter of challenge, as a primary authority, can you look into your allegation now? That is what we are trying to put.
My allegation is that during the period of his MLA.
No, that allegation is okay, but see, as a writ court, we do not have the facility to even look into your allegation, whether these allegations are correct. You even do not have the expertise to either, you have to adduce evidence, but these are matters which will come later. Right now, we'll only have a prima facie view whether the procedure adopted is correct or not.
My lord, the first procedure is that they have written a letter on 13/1/2021 that secretary to the political department should give the approval for this. For this, they have followed 17A subpoint C. In the case of any other person.
Yes, please, for the government. If at all sanction is necessary, he is contending the sanction may not be necessary at all. But if at all a sanction is necessary under 17A, who is the competent authority so far as the ex-MLA is concerned? See, he will not have that control over from whom the sanction is sought for. It is up to the police authority. He will not have any control. If the police authority asks for a sanction from an authority who is not competent in law, he may not have any control. But is it proper on your part? Who is the first? Who is the competent authority? That was the question exactly posed by this court on the last occasion. Yes. No, that is the instructions you required to put, because this is the order, last order, straight cut order. See, the question was put to the petitioner. He has said it is the speaker.
Yes.
Do you have any difference of opinion? See, if it is the speaker, then we may have a recourse tentatively to redo the exercise of seeking a permission from the speaker. After that, after hearing, if we are convinced that sanction is necessary under 17A, because it also uses the expression investigation, not for prosecution. And this letter had sought for having a regular inquiry.
RE report has been submitted, Lordship.
Who-
RE report has submitted.
Who has submitted?
The Vigilance and Anti-Corruption has come. This is
By-
the
by-
findings of the RE. Report has not been given. They are not submitting the affidavit.
Which order? Which order? 10 June we have, it has been placed on record. Where is the RE report? You get the RE report, get the specific instruction as regards who is the competent authority under the PC Act so far as an ex-MLA is concerned. That must be very specific. Since he is an ex-MLA.
Yes, my lord.
Mr. Chaudhary, what do you say?
My lord, after the amendment of my lord, the 2018,
Yes,
there is no difference between an ex-MLA and a present
Okay,
MLA.
okay.
Be it section 17 or 19 is
19,
required.
okay.
Now, my lord, kindly come to the writ petition, their prayer. Now, one cannot be, before that, my lord, I would like to place one thing, my lord. Please permit me, because my learned friend was shouting at the top of his voice. I'll show why he was shouting, my lord. That we have brought out
So
in our
leave
affidavit.
those.
No,
aside.
no, no, my lord. One
Those
thing
have
very
been taken
important.
care of.
No, my lord, it's very important. Please come to page 49.
49,
Our affidavit.
49,
Oh, sorry, my lord, 48.
48.
Yes,
Your affidavit,
yes, my,
10 June. 10
yes.
June,
my lord.
10 June.
Yes,
Okay, we have it.
please come to page 40, or page 47, para 3, my lord.
47,
Yes, page 47, a few lines from the previous page.
yes.
The writ petition suffers from gross suppression of material fact. Petitioners have projected that,
Just a minute.
my lord, our affidavit filed by respondent number 5.
It is not 48, this will be something.
It starts at
No, no.
page 46.
No, no, it's a different. As per number 5, it starts at, there are paginations, there are
Oh,
problems.
oh, okay.
Page 50 doesn't matter.
Yes, please come to
Eh,
para 3, my lord,
yes.
last piece sentence.
It starts at
At the very outset,
yes,
yes.
yes.
Please read last piece sentence.
Yes.
The writ petition suffers from gross suppression of material fact.
Mm.
Petitioners have projected themselves as diligent and duty-bound citizens, voicing their concern regarding corruption,
Mm.
but they have willfully abstained from disclosing that there are ongoing civil litigation between the petitioner number 2, that is my friend, and answering deponent's wife. Such litigation include pending arbitral proceeding under section 9 of the Arbitration and Conciliation Act, being arbitration case numbers so and so, and a dispose of application for appointment of an arbitrator, being petition number so and so. The dispute among the parties is regarding allotment of landowners' allocation in an apartment building constructed by the proprietorial farm of the wife of the petitioner number 2, which was illegally and fraudulently taken over by petitioner number 2, posing as a representative of the answering dependent wife. So this is the, my lord, background.
My lord.
Now, my lord, time has a quarter. My lord will kindly come to the other aspects, my lord. Now, please come to the prayer in the writ petition. Because this honorable court posed a question, now he has become wiser. Prayer number 1. A writ in the, at page 17, a writ in the form of mandamus or any other writ as deemed fit by honorable court shall not be issued, thereby directing respondent authorities, specifically respondent number 2, to take into consideration the approval request for initiation of criminal case against the suspect officer Dullab Promoa as sought by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption Assam by this letter dated 13/1/21, and after perusal of grant immediate appropriate government approval sanction for or rejection as the case. So his case is, my lord, government should grant. That is his case project. Now, as your lordship has already pointed out, section 17 and section 19 operate in two different fields. Section 17 speaks about, my lord, approval to start an inquiry or rather investigation. And section 19 speaks of, my lord, prosecution. Prosecution sanction. Now, my lord, section 19 has been refused. The only option left to them is to challenge that order.
Not 19, 17.
My lord.
17 has been refused.
Not necessary, my lord. No, 17, no, 7, it's not 17A, my lord. If Lordship kindly comes to next page, second page of that order dated 10th of June,
Yes.
if your Lordship should kindly come to the last para.
Hmm.
After perusal of the report submitted by SP Vigilance and Anti-Corruption dated on allegation against Durlabh Tomua, the proposal submitted by SP for giving approval to initiate criminal case dated so and so against is hereby denied. So following 17A permission investigation, some sort of was done. Thereafter, my lord, 19 was sought. 19 has been refused.
But one point which petitioning person is
No,
trying
that
to
is
raise
that is a point,
is
my lord.
regarding the competent authority.
So who is competent?
Who
Yes,
is competent
that's a
authority?
very relevant query.
I think
Perhaps, my lord, perhaps-
we take the view of the government and let him clarify, because he has emphatically said that it is the speaker and it is in response to the query put to him on the last occasion.
There he may be correct also, my. Maybe it is the speaker. Preponderance of judicial views seems
No,
to be
prior
that.
FSI, it appears to be the speaker.
Yes.
MLA, ex-MLA.
Yes.
No other, so it's not the political department. Cannot be.
My lord, this state department, if a lordship would kindly come to that order, please come to that first page of that order, where initially the mistake was done, my lord. Fourth subpara.
Yes.
Whereas judicial department under aware of the view that in the instant matter, Durlabh Tomua being an ex-MLA, in the light of the decision of the Honorable Supreme Court in Surinder Kumar Bansal, it is stated that prosecution sanction to prosecute him for offence and is not required. Because this was under the unamended act. The following, the amendment is, my lord, with effect from June, I think, 18, my lord.
That is
And
yes.
the alleged occurrence is of, my lord, November 28. So post amendment. So therefore, the view of the judicial department.
What is
was
the
not
date
correct.
of your complaint, Mr. Butcher?
My lord, I have filed complaint on 27/11/2018.
After amendment.
Learned senior counsel has made some submission in regards to disputes, so-called disputes.
No,
Lordship-
that we are not commenting. We'll take the appropriate call.
Already has been, reply has been submitted, Lord.
That will take into consideration. Mr. Handik, Mr. Handik. We put it specifically in the order so that it's not, it becomes easy for you. When can we have this? Matter otherwise appears to be serious. If there is something, we'd like to look into this matter.
Lordship, I have just small submission in the order itself of the government. You will find that the government ordered an inquiry on 15/5/2023 when this matter is pending before this court. Vigilance and Anti-Corruption submitted its report on 25/2023 when this matter is pending before this court. Within a period of 5 days, a regular inquiry report has been submitted to the government without even informing the petitioners who are the complainant, and the matter is pending before this court. Neither they are informing this court, nor they are giving the information by RTI Act. And if they have been given long times, it will already.
Tell us
further
when will you be able to get the instructions? We fix a date. He appears in person. Okay.
You can have it in first week of April.
Tell us a date.
To the first,
On
second, any
four-
date, my lord.
On 4th,
My lord,
Thursday,
fourth, I am,
3rd.
yes, third.
3rd.
I am optimal. Third.
This court, on the last occasion, that is 12. No, would be good. You're not here. This court on the last occasion, i.e. 12/2/2024, had made the following query. It lasts for, full stop, I can list on so and so, on so and so. Sri B. Bucha, the petition number 2 in person, has submitted that so far as an MLA/ex-MLA is concerned, comma, the competent authority under Section 17A of the Prevention of Corruption Act 1988 would be the speaker. Full stop. He accordingly submits that the order passed on 10/6/2023 by the political (vigilance cell) department is non-est in law, as the same has been passed by an authority without jurisdiction. Full stop para. Let specific instructions be taken in this regard by Sri J. Handik, Learned State Council. Full stop. Sri K. N. Chaudhary, Learned Senior Council, assisted by Sri N. Chaudhary, appears for the respond number 5 and submits, and by referring to the prayer made in this petition, has submitted that the stand of the petitioners are wavering and not consistent. Full stop para. This aspect of this matter would also be considered on the next, considered subsequently. Full stop para. As agreed to by the parties, list on 3rd of April. Full stop. Sri Handik, the Learned State Council, would invariably get the instructions as indicated above.
Keep it.
May physiology. This is regarding renewal of pharmacy license.
Well, I got the inspection, my lord. As per my inspection, my lord, the certificate at page 36 regarding, my lord, completion of internship, my lord, that is found to be fake. I will find my affidavit. He has come up with some certificate.
Mr. Goswami, fake documents.
Principal has given the certificate, given the report that he has not. In fact, the issue number is. I will file my
Sri C. Goswami, Learned Counsel for the petitioner. Full stop. The issue involved.
Let them file.
Yes. No, we are not dismissing it. We're giving time to file affidavit.
At least that
the issue
petitioner
involved.
could know what is what.
The
Exactly.
issue involved is non-grant of pharmacy license. Pharmacy license.
No, my lord, this is regarding my.
Pharmacy license. No, he is a pharmacist, my lord.
No.
Renewal of pharmacist.
Is issue involved is non-renewal of the
As him as pharmacist.
renewal of the registration as pharmacist of the petitioner. Full stop para. 3 B. Gogoi, Learned Standing Council, Health.
But yes,
Assam Pharmacy Council or what?
Assam Pharmacy Council.
Learned Council appearing for the Assam Pharmacy Council, COUNCL, however, submits that the document of the petitioner are not found to be ordered. And in fact, there is an allegation of forged document. Full stop para. Let an affidavit be filed by the respondent council, COUNCL, for which 3 weeks time is granted.
Okay, sir, I am being not adjusted for a week, my lord, as I am not feeling well, my lord.
Okay, why are you waiting then? You could have gone. Yes.
That may kindly be fixed.
On the prayer of, what is the issue?
Unauthorized construction. Lord. He has done unauthorized construction. That is to be removed.
Already some demolition has been done, my lord.
See, demolition has already made his health condition bad. Don't go for more demolition now. He's not feeling well because of demolition. Okay, after a week? Miss, yes, you need a date? Which date? Tell us.
On 21.
So Mukhtar, you agree on a date?
21.
21. Heard 3. D. Barua, Learned Counsel for the petitioner. Full stop. Para. Also heard 3 S. Mukhtar. S.K. Mukhtar, Learned Counsel for respondents 4 and 5. Who, however, prays for some accommodation. Hosts for GMDA, GMC. GMDA, GMC. P. Nayak, Learned Standing Counsel. GMD/GMC is present. Full stop. Para. As agreed to by the parties. List on 21-3. 21-3.
Fine, apply.
Is there any interim order? No.
No, Lord.
My lord, I have filed the counter affidavit on 13th February.
You're for
with
which
the
department?
affidavit in opposition of respondent 5. Others have not filed any affidavit.
You're for the petitioner?
I am for the petitioner.
You have filed rejoinder to the respondent numbers 5?
Yes, ma'am.
Okay. When did you file?
13th February.
Ah, no, I don't. Kyun nahi? Yes, who's appearing? Have you? You're for whom? Revenue Department? Who is for R5?
R5 is.
Mr. Handik, you are there for R5. You have received a copy of the rejoinder. That is not in record. What is your name?
P.K. Bora.
Sri P.K. Bora, Learned Counsel for the petitioner submits that against the affidavit in opposition of the respondent number 5, a rejoinder affidavit has been filed on 13th of February 2024, which however is not with the records. Full stop. You need time to file.
Yes.
At the same time, Miss Ann Bordeler, Learned Standing Counsel, Revenue Department, prays for some time to file affidavit in opposition. Full stop. Are you an obsession counsel?
Pardon?
Are you an obsession counsel? No. you're
Yes,
from-
I come from Shillong.
Okay, you tell us a date.
Yes.
Of your convenience. We'll give some time after around 3
After
weeks.
4 weeks, maybe.
4 weeks. Tell us a date.
April. Yes.
Let Mr. Bora have a date of his choice. He's an obsession counsel. Today is what? 13th. We can have it on 18th.
22nd of April, my lord.
22nd is okay for you? Okay. List on, as agreed to by the parties, list on 22/4/2024. Full stop. In the meantime, further pleadings may be exchanged and the rejoinder affidavit of the petitioner may be brought on record, may be tagged with the records.
Right.
Interim order also nahi.
May I please, Lordship?
Yes.
This case is relating to non-payment of ex gratia relief.
Okay.
My son died as the result of a road traffic accident.
Okay, madam, your response?
I'm awaiting the instruction, directing the deputy commissioner to verify the case of the petition.
You get the instructions at least, factually, is it correct or not? We'll give you 2 weeks time, but we'll fix a date.
Yes.
Item number. Your Decca, R Decca. First three R Decca, Learned Counsel for the petitioner, who submits that the matter relates to a claim for ex gratia for the death of the son of the petitioner in a road traffic accident. Full stop. Para. MSN Bodler, Learned Standing Counsel, Revenue Department, however, submits that instructions are awaited. Full stop. Para. Considering the subject matter, a further opportunity is granted. Fixing this matter, directing listing of this matter After? After 3 weeks. But next day we'll dispose this of.
That may be.
Respond number 3 also may be directed.
3 is who?
Deputy Commissioner.
Anne Bordloy as well as J. Hendrik, state respondent. List on 5th of April.
Alright.
5-4.
Let-
Mr. Bonik, what is this?
My lord, we are elected members
Of,
a corporate society.
okay.
Election was conducted, was held, and the certificates were declared, the polling was over. Now suddenly, the unfortunate part was that the meeting was being conducted by a one-man committee, their man. Now,
How do you know it's their man?
it's a one-man.
It may be your man also.
He's an official person. So, once the election, as you know, my lord,
We
under
do
the
not, we do not know anything. How do you presume you know?
in a meeting.
Your facts, how do we know? Tell us.
My lord, that gentleman, the one man, he suddenly fled from the meeting. He suddenly fled.
Fled where?
We don't know where he went, but he went away.
He was facing an FT proceedings or what?
Nothing. He just went away.
No FT proceeding against
Nothing.
him.
He fled. And this incident was seen or looked at by the registrar as the board.
He is a
has-
government servant, isn't
He's a
he?
government servant.
Then where did he go?
We don't know. He left.
Stokos has been issued, my
He
lord.
left.
Unauthorized absence.
In fact, my lord, he was in the midst of the meeting, he
He
left. My lord, he abstained from discharging his statutory duty. Now registrar has issued a Stokos against him.
Parallelly,
Otherwise, he is in service or not?
He is in service, my lord. He is in service as the, my lord, perhaps senior inspector or auditor. He is in service. But
He is attending his duties elsewhere, but not as in this capacity.
No.
He is not serving anywhere.
That I don't know whether he has
Rajanikanta does.
placed under suspension or not. That I don't know, my lord.
Okay, then what happened?
now this was viewed by the registrar that the board has to be dissolved. Here we have it. We say nomination, scrutiny, election, everything was done. Under the extent act and the rules, normally whenever there is an,
But why was the occasion to run by a one-man committee when you had an elected
so
body?
that was on the last body, they could not complete, so a one had come in.
Okay,
Now, we have no difficulty with the one man. One man convened the elections and the AGM.
you are the new body.
No, we are not the new body. We participated and then we became the new body.
But that is your
But yeah,
people.
absolutely. And now our election has been set aside.
Set aside by whom?
The registrar,
On whose complaint?
the matter was being followed up by the authorities. And eventually at page 55, the order came up. People were there objecting. It was treated to be an appeal.
Mr. Talukdar, you have filed affidavit.
My lord, I have.
They have not objected. They only say that the proper
Can-
course of law was not taken.
Can something be done today?
Yes, absolutely.
Tell us what can be done.
My lord, so far, if Lordship would have this, the election rules, my lord, for a moment, my lord. I mean-
Which book are you?
This,
Cooperative Societies Act.
my lord. One which has the rules. There's one independent circulation, which
Lordship may take up this one. Rules are there.
one might not have the rules as well.
It is one.
এখন কি বলো ফোন কি নাম এখন নাম কি এখন এনেকুৱা আমাৰ এখন আনিব লাগে দেই এইখন আজি লিখি দিব ক'ৰবাত এইখন পঠিয়াই দিব আৰু এইখন নহয় এইখন লাগিব উইথ এইবিলাক ৰুলছ থাকে
Page 109 of that.
Yes, please.
109 of that. Rule 3. Conduct of election to Board of Directors of Cooperative Society. A. Subject to the superintendent's direction and control of the registrar of cooperative societies, Assam, the following officers shall have the power to conduct elections as per section 41(1) of the Act as delegated by the government from time to time, namely registrar, joint registrar, deputy registrar, and an assistant registrar. We skip it for a moment. Now, The election of the cooperative society for constitution of the board of directors shall be held in a general meeting, in a meeting of general assembly as per section 29 of the act, if fallen due as per section 31, 41, 42, or section 33 on such stage as may be notified by the registrar of cooperative Assam. We still leave it for a moment. The relevance is C. On the notified date, the AGM, which inter alia shall have the election agenda, shall fix the schedule. Now, all this part were over. What I am trying to say is that normally in AGM matters are discussed. In some AGM, elections are held. That election is an agenda. So far as the election agenda is concerned, it has reached the finality. Once it reaches the finality, winner certificate declaration. I have annexed a document. I'm not reading that. Very sure. Now, what remains after this is, if there's some difficulty on this score, then 19, rule 19, that is adjournment of poll. This was not done. If the continuance of poll is disrupted by certain circumstances beyond the control of the returning officer, it did not happen. Poll was peaceful. 19, 20, countermand of poll. Countermanding was not done.
Now, why are you showing this? These are
Because
not-
election reached the finality.
Oh,
So
yes.
therefore, the order by the order impugned is on the face of it valid law.
Where is it?
Page 55. There can be cancellation, repolling, or countermanding. Nothing more than that. Page 55.
5.
55. Second paragraph onward, if I may read. Peruse from that part. Input not to the-
Yes.
Peruse the document submitted by the petitioners as well as the respondent. It
You-
was found that
There
as
were earlier court cases or what?
earlier cases leading to that the objection petition is appeal. That appeal was taken up. It was
Yeah.
found that as per Honorable Guwahati High Court order dated so and so, the Zonal Joint Registrar of Cooperative Societies Guwahati so and so appointed Sri Rajanikanta Das, Junior Inspector Auditor of so and so, as chairman of one-man committee of Goroimari GPSS Limited by order dated so and so 3/1/22. It also found that the one-man committee submitted resolution to the office of the ARCS for holding AGM on 28/12/22. Accordingly, the returning officer and the assistant returning officer had been deputed to conduct the election agenda of the AGM on 28/12/22 of the society. It was found that on the day of the counting of the ballot papers on 30/12/22, the returning officer and the assistant returning officer of the AGM so and so had to face a critical situation because Sri R.K. Das, chairman of the one-man committee of the Goroimari so and so, remained absent willfully on the day of counting. As reported by the election officers, the election agenda had been conducted smoothly by the election team, but due to willful absence of the chairman of the returning officer, they could not hand over the charge to the chairman to complete the other agendas of the AGM. That's what I was on. The Zonal Joint Registrar of so and so dissolved the newly elected board of directors of the society and appointed a one-man committee to run the affairs of the society. The order was apparently issued by invoking jurisdiction under section 39 of this act for violation of section 32 of the act because of the fact that the previous one-man committee entrusted with the responsibility of holding the AGM election had left the venue of the meeting before completing 8 of the 11 agendas of the meeting. The petitioners appealed that the remaining agendas should be completed by appointing a new one-man committee.
So the order has cited violation of section 45.
Oh.
If we read 45, minutes of proceedings of meetings,
Lordship.
that is the principal ground of passing the order. Please
45.
read 45.
It's also a deeming condition, Madam. Every cooperative society shall record in the minutes books in the official language of its station or in English or in any other language prescribed in the bylaws, proceedings of every general meeting, delegate general body meeting, and board meeting, and the names of the members of the delegates present thereat shall be confirmed at the same or the next meeting. The proceedings of all general meetings and special general meeting of every cooperative society, complete in all respects as in the act and the bylaws, shall be sent to the registrar within 15 days from the date of the completion of such meeting with due acknowledgement. The registrar shall give his approval on the resolutions within 15 days of receipt of the proceedings. If no approval is received within the aforesaid period, the proceeding shall be deemed to have been approved. The minutes so recorded shall be signed in case of general meeting or delegate general body meeting by the person who presided the said meeting, or in the event of his death, unwillingness or incapacity to sign the minutes within the time required by the chief executive of the cooperative society for the purpose of submission of proceedings for approval, and which shall be confirmed in the following meeting. In case of a board meeting by the person who presided at the said meeting, or the person who presides the following meeting, when the minutes are confirmed. In matter of inclusion of any other matter, that's not.
Now, what can be done?
Secretary
today?
could have signed it.
Tell us what can be
So
done.
far as the
today?
election is concerned, election by operation of law is valid. The other agenda, my lord, I leave it to them, what they opt to do. They want to hold it. I am no one. The elected body is
Mr.
complete.
Talukdar,
If we come in, we come in.
what do you propose?
15 are there.
My lord, I have filed the affidavit. In fact, the query of the honorable court was, they say, my lord, in the petition, that this is a case of 34. 34 means quorum. So the honorable court directed me to obtain instruction and file the affidavit, whether there was quorum or not. In fact, my lord, the instruction goes in their favor. There was a quorum. And if, my lord, your lordship finds that 34 applies, one, my lord, once there is a quorum, so they will have the benefit of holding the subsequent meeting. This law has been settled. So that I leave to your lordship, whether they are entitled to hold the subsequent meeting. If the subsequent meeting is held, my lord, then they carry on, my lord, the remaining agenda. But the election, my lord, as my lord appears from the record, election is complete. Perhaps, my lord, the winning certificate has also been.
We have winning.
No, that we have seen.
We have winning.
Yes.
We have winning.
So therefore, my lord, whether subsequent meeting will be held or not, my lord, that your lordship will, my lord, take care of.
So the one man would not hold the other part of the agenda. The new board which comes in would carry out the subsequent agenda.
Only that much.
That much. The understanding was wrong by the registrar. That's what we say. So section 45 would lead to a secretary sending the same document. So whether or not the registrar signs it or not.
Okay. Heard. Sri Bonik Learned Counsel for the petitioners. Also heard Sri Talukdar Learned Standing Counsel, Cooperation Department, who has also filed the affidavit in opposition on 6/1/2024, full stop. Para, considering the subject matter involved and as agreed to by the parties, comma, this writ petition is taken up for disposal at the admission stage. Full stop. Para. The projection made in the petition is that the petitioners, who are 13 in numbers, are the shareholders and candidates and the winning candidates of the AGM election of the concerned Samabai Samiti, namely Goroimari GPSS Limited, Kamrup, in the elections held on 28/12/2022. Full stop. After completion of the election, comma, in the course of the AGM, comma, a one-man committee was appointed to run the same said meeting, full stop. However, without completing the agenda, comma, the said one-man committee had left the venue, whereafter as a result of which the rest of the agenda could not be discussed, full stop. It is, however, the categorical case of the petitioners that so far as quorum of the AGM is concerned, comma, the same was complete, full stop. Para. Since the AGM could not be completed, comma, the impugned action was taken by a series of orders dated 12/1/2023, 11/5/2023, and 15/9/2023.
21/8 is also there. Page
20
49.
21/8/2023, full stop. Para. The last order dated 15/9/2023 has been passed by the Registrar of Cooperative Societies pursuant to an earlier direction of this court dated 7/8/2023 in WPC 1201 of 2023. Full stop. By the said impugned order, the AGM/election held on 28/12/2022 has been held to be invalid on violation of Section 45 of the Assam Cooperative Societies Act 2007. Full stop. Para. Sri Bonik, the learned counsel for the petitioners, have submitted that the impugned action is not sustainable in law and for no fault of the petitioners, the AGM/election held on 28/12/2022 has been interfered with. Full stop. By referring to the materials on record and the annexures, Sri Bonik, the learned counsel for the petitioners, has submitted that all formalities were completed and over, and it is only for the fact that the one-man committee who was appointed to run the AGM had left the venue midway that the impasse has been caused. Full stop. He accordingly submits that since there is no violation of any provisions of the statute holding the field, the petitioners may be allowed to hold the meeting and decide upon the other agenda fixed. Full stop. Para. Sri Taludar, the learned standing counsel, fairly submits that as per instructions received, there is no objection with regard to the manner and mode of holding the elections, which was complete. Full stop. He also submits that even the provision of quorum was fulfilled by presence of the requisite numbers. Full stop. He accordingly submits that appropriate orders may be passed in the interest of justice. Full stop. Para. After hearing the learned counsel for the rival parties, this court is of the view that interest of justice would be served if the petitioners are allowed.
No, my lord, in fact, now the departmental officer will hold the subsequent AGM and complete the agenda. Thereafter, proceedings will be sent to the ARCA.
No, but the officer
So we
is
formed
not
the
there.
board. We formed the board.
Thereafter, they will form the board.
Oh.
We would not be outstanding.
Just,
no? Would not be outstanding.
Justice, if the meeting is held for completion of the remaining agenda, full stop. Accordingly, it is directed that the corporation department would make necessary arrangement, including appointment of a one-man committee, of a chairman to conduct the meeting and meeting on the remaining agenda. Whereafter, the board of directors may be formed in accordance with law. Full stop. The subsequent course of action would be done by strictly following the provisions of the statute holding the field.
Outer limit may be given.
Let the aforesaid exercise be completed within a period of 3 weeks from today.
If I may suggest, one liner would be necessary, that the election of the petitioner shall not be interfered with.
That we have already said.
That
He's
that is not expressed, but he is here tomorrow. The election of-
After now, hearing submission to go after consideration, this court is of the prima facie view that the elections of the petitioner does not suffer from any illegality or infirmity.
I'm grateful.
I have received my instruction. I'm going to file an affidavit.
What is the matter about?
May it please your lordship. Lordship, on 17/2/2023, the petitioner filed a RTI application for some information with regard to his parental property. Thereafter, he didn't receive any information. Thereafter, he exhausted his first appeal and then second appeal as well. When he approached for the second appeal, the communication came from
Second appeal under the RTI Act?
RTI Act.
Okay.
So it was the public information officer was the Dispute Circle Office, and thereafter the first appellate body was the Deputy Commissioner, your lordship. So on 17/7/2023, the Deputy Commissioner directed the Circle Officer to provide all the documents within 7 working days. He could not offer any of the documents. On 25/7/2023, he communicated to the petitioner that the documents will be provided if they are found as and when they are found. That was the entire reason. That is the entire reason because of which the petitioner has approached the court, because there is no time bound, there is no time stipulation. And on the last,
Why haven't you made the Information Commissioner party?
lordship, so what happened was,
No, you should have made the Information
No, your
Commissioner party.
lordship,
We
when
could have,
he
we
went
could have
for the-
bound, we could have bound them.
No, your lordship. So what happened was, the communication for the first hearing from the Deputy Commissioner came very late. So meanwhile, the petitioner already went to the Chief Information Commissioner. So when the hearing took place with the Deputy Commissioner, he gave a direction, and when the case was already filed before the communication from the Chief Information Commissioner came for a hearing. So since there was no time limit or no time stipulation which was followed by any of the public authority, so that is the reason he approached the court, your lordship. So when this matter was filed, the Chief Information Commissioner didn't even call the petitioner for a hearing, because as per him, the matter was taken care of by the Deputy Commissioner, even though it was late, because the second appeal was filed on 30/5/2023, and the hearing was done on 17/7/2023. And the Deputy Commissioner was bound to provide the information or hold a hearing within 30 days. Your lordship.
Yes, how soon can you file the affidavit, Mr. Hendrik?
Yes, my lord, that they have not told regarding my lord that RTI.
What is your name? Rajendra Kumar Deka.
Is the petitioner.
You put this on an affidavit so that he also
Lord-
knows what
Lord-
is your stand.
That time, my lord, I did
Okay.
some time. Already affidavit.
Three,
here.
J. Henry Glenn State Council submits that written instructions have been received on 27/2/2024. Full stop. Let an affidavit be filed by the state respondents, which is required to be done within a period of
2 weeks, Lord.
2 weeks from today. You take this back.
Lord. God bless you.
34.
Lordship, kindly pass over the case for timing as my senior art club is on day. I'm appearing for 1/7 matter and for the corporate department and on behalf of the Rajkot Standing Council, Lord, our application for the date can send for time, but delay occurred due to transfer of the office.
Yeah, for whom? Respond of
1/7 corporate department.
Corporation Department. Okay.
10 days time may be gratified.
My lord, otherwise I could not object, my lord, but the difficulty is that, my lord, the respondent number 9, my lord, who has been reinstated as a chairman of the society, my lord, pursuant to an order passed by this honorable court, particularly for the reason to hold the no confidence motion, my lord, afresh, because the earlier one held to be not in accordance with the law. Now, my lord, some huge embezzlement has been done with the monetary effect, my lord. That's why this person is absconding, my lord. As a result, my lord, what has happened?
Who is absconding?
This respondent number 9 chairman, present chairman, my lord.
No, he's appearing.
No, they are appearing, but the person, my lord, physically is not available in the office,
That
my lord.
cannot be. If council is there, how can the person be held to be absconding?
No, my lord, in the office of the society, my lord, is not functioning due to his he has
Mr. Islam?
already, my lord, he has.
Where have you gone?
But I'm still there. Still there, but
Please
not.
see, Mr. Islam, where have your client gone?
My client, my lord, is still
He is
there.
still there.
And recently, he has submitted like that, my lord, because they have lodged an FIR after passing the judgment of this honorable court.
No.
And he has already taken, no, please let me submit. He has taken the anticipatory bail, interim bail, and they have given an objection. First interim bail was rejected yesterday, day before yesterday.
You have
So that's why
lodged an
he has
FIR.
said that he is absconding, but he is still in the office. Thus, day before yesterday, the bail petition has been rejected. That's why he said like.
No, my lord, it is
Before
not.
that,
it
he
is,
is
no,
still there.
I am opposing to my respected senior friend submission, my lord. It is not like that. This person has embezzled more than 12 lakhs, my lord, from our society, my lord, from the fund of the society, and it has been proved in the report as well as
Who
the.
are, who
My
are
lord.
you? Who are you?
My lord, we are the board of directors members, my lord. All together, 8 we are here, my lord. Before my
What
lord.
is your grievance?
My lord, our grievance is that regarding his reinstatement and my lord, the
Respondent number 9.
reinstatement of the respondent number 9
As
the chairman, my lord, as the
of
chairman
your board.
of the board, my lord, because he was earlier, my lord, removed by of a no confidence motion, my lord. But in that no confidence motion, there are some technical errors were been detected by this honorable court, my lord, and that's why that, my lord, this no confidence motion has been held to be illegal and set aside, directing to hold the meeting as a fresh, my lord. That is an
No.
admitted position.
No, you have
Now,
held the
in
meeting.
that meeting, my lord, what has happened in such a manner, the meeting was convened by the, my lord, respondent number 9. That, my lord, even we do not know that when the date has been fixed, no notices, nothing has been served on us, my lord.
You are challenging the second meeting.
My lord, second meeting as well as, my lord, he has already been terminated by in operation of section 23 of the Cooperative Societies Act. His membership has already been terminated, my lord. And in now, my lord, under that situation, he has not challenged his termination till date, my lord.
Termination under why?
My lord, under section 23 of the Cooperative Societies Act.
What
my lord.
does it say?
Lord, it says that.
Yes, we have.
My lord, at page 24 of this book, my lord.
Yes, we have.
My lord, section 23, termination of membership, the board may, by a resolution passed by a 3/4 majority of the directors present and voting at a meeting held for the purpose, terminate the membership of a member if he intentionally does any.
Who has
act.
terminated him? You.
My lord, the board has terminated the. my
You are
lord,
the board.
we are the board, my lord, at that relevant period of time, my lord. And because.
How many members are there in the board?
My lord,
15 members.
15 members, my lord.
You are how
15.
many?
We are, my lord, at present, before my lordship is 8, my lord. 8. Out of 15, we are 8. And during the termination resolution, my lord, there were 12 members were present, my lord. My lord, maybe verify the termination.
But the termination has to be by 3/4 majority.
My lord, my lord.
Where you 3/4?
3/4, my lord. Out of 15, 12 was there, my lord.
Where
12
were there?
was there. My lord, maybe please to verify the resolution of the termination, my lord, please.
Okay, madam, you file the affidavit.
My lord, my lord. My lord, only a short
Then
date may be given,
we'll
my lord.
hear this matter. It appears
My
to be
lord.
contentious.
Because, my lord,
You
the.
have filed affidavit, Mr. Islam?
Yes, I have
my
already
friend
filed my
has
lord
filed.
and brought the entire fact. And he has stated that he has no knowledge regarding the notice ballot. I have already annexed the peon book.
Yes.
Where the 3 petitioners putting their signature and received the notice. Others notice has been sent through the WhatsApp message. That has already been received by them.
Okay.
So
Heard 3AR via learned counsel for the petitioners.
inter suppressing the material.
Also heard 3R Islam, learned counsel for the respondent number 9,
9.
who has filed affidavit in opposition. Full stop. Para. Miss B. Bora. P. Bora. Learned counsel appearing on instruction of Sri V. Raskwa. V for victory. Standing counsel, Cooperation Department, appearing for the respondent numbers 1, TO27. However, submits that the affidavit in opposition is ready and would be filed shortly. Full stop. And you for? Who's it? File affidavit? Will you file? No. Okay. As requested list. Yes, we fix a date.
My lord.
Tell us.
But on the 28th of March, my lord.
Yes, he's suggesting 28th March. Is it okay?
Maybe it on April 1st week, my lord. 28th March, I will.
2nd of April. 2nd April.
Mal.
Yes.
2nd April. The respondent number 8 may also file the affidavit in opposition in the meantime.
Mal. Oblige me.
Yes.
Okay, Parasite has not instructed. To tell us if this is regarding the issuance of Christian marriage license.
Issued.
Today.
Heard Sri K. Mira, learned counsel for the petitioner. Also heard Sri S. Datta,
For respondent number 1,
learned
2,
standing
3,
counsel,
yes, sir.
Revenue Department. Full stop. Para. The facts projected, considering the subject matter in dispute, comma, the developments which have taken place, and as agreed to by the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Full stop. Para. The facts projected is that the petitioner was functioning as a priest, that is, i.e., minister. You call it minister?
Yes, sir.
Minister of religion within Khasi Jayantiya Presbyterian Synod. Synopsis. Synod MIHNGI in the district of Kachar. Full stop. As in the said capacity, comma, one of his duties is to solemnize marriage, but To do so, comma, a license is required to be issued by the state government under section 6 and 9 of the Indian Christian Marriage Act 1872. Full stop. In this connection, comma, number of representations have been made to the competent authority, which however did not yield any results. Full stop. Para. Does situated, THUS, does situated, comma, the petitioner had earlier approached this court by filing WPC 7045 of 2022, which was disposed of wide order dated 11/11/2022 by this court, directing the petitioner to approach the district registrar, comma, Kachar, within a specified time by and submit application which was directed to be considered. Full stop. The petitioner also had to file a contempt case number 278 of 2023. Full stop. Para. As so subsequently, comma, on certain assurance, comma, the contempt petition was closed. Full stop. However, comma, the license was yet to be issued to the petitioner, and therefore the present writ petition has been filed. Full stop. Para. This court, wide order dated 13/12/2023, had issued notice in this matter. Full stop. Para. In the hearing today, comma, Sri Datta, the learned standing counsel of the department, has however informed that a notification has been issued on 13/3/2024, as per which license under section 9 of the Indian Christian Marriage Act 1872 has been granted to the petitioner, on the strength of which he would be able to solemnize and issue certificate of marriage. Full stop. Para. This court has para. A copy of the notification dated 13/3/2024 issued by the Principal Secretary, Revenue Department, has been placed before this court, which has been perused. Full stop. Para. On a direction of this court, comma, a copy of the same has also been furnished to Sri Meera, the learned counsel for the petitioner. Full stop. Para. Considering the aforesaid development, including issuance of the notification dated 13/3/2024, comma, this court is of the view that since the license to the petitioner under the Indian Christian Marriage Act 1872 has been granted, wide the notification dated 13/3/2024, comma, the grievance of the petitioner stands redressed. Full stop. Para. The writ petition accordingly stands closed.
Apply.
Para. Copy of the notification dated 13/3/2024 is made part of the records.
Okay.
May I please your lordship respondents have not filed their affidavit in opposition yet.
30.
But I have received inspection, my lord, covered matter.
What is the instruction?
To the person to their request for appointment of arbitrator, my lord, we have replied to the letter to the party concerned, my lord. My lord, the instructions. Next, second page, my lord, is the letter dated 1/11/2023.
Yes.
So, my lord, regarding subject of appointment of arbitrator, there, my lord, we have categorically mentioned that in reference to the above notice, I would like to bring to your kind attention that total amount claimed 3,25,42,052 is 41.03% of the standard contract value of 7,93,05559 as per clause 16(2) of the contract agreement. The provisions of clause 63 and 64 to the general conditions contract will be applicable only for settlement of claims in the parties for values less than or equal
One,
to-
I think one of the matters we have disposed of.
Yes,
If
my
it-
lord, this is.
Dispute is less than 20%, it will not be
Same
arbitrable.
party, my lord, same party was.
Madam, what do you say?
This is the judge.
Lordship, another date may be fixed, my senior
Who is your senior?
are sick.
He was there in this case also. There was there. Same party, my lord, ATWD here.
I think we have also disposed of one matter, but we have dealt with one matter. We remember your submission. If it's less than 20% of the
Yes, my
total.
lord, that, I have filed the writ, my lord, but that was.
Okay, well, when can we get back? Day after tomorrow? Day after tomorrow, we'll dispose this of, okay? An adjournment has been sought for on behalf of Sri R. Hussain, learned counsel for the petitioner, for Tapera. On the other hand, Sri H. Gupta, learned CGC, representing the respondents, has submitted that the present petition may not be maintainable as the dispute as projected would not come within the meaning of an arbitrable dispute. For Sapara, be that as it may, and in the interest of justice, the matter is adjourned to be listed when? Monday next? Monday. Monday next. You place this on Monday again. What is the matter?
This matter may be listed, my lord, along with another writ petition, my lord, 7182/2023, arising out of same case, same second part of it.
What is the matter about?
Regarding your lordship,
Eviction,
this was an Exonia land strip. We have it, it's regarding,
There is an interim order.
no, it-
Interim order is there, no coercive action. There is an interim order, madam.
there's an-
yes, it is matter, madam. So my humble submission, is this matter may be listed along with the writ petition, my lord, 7182.
What do you say?
Yes,
Yes, ma'am.
there's six or four times.
Miss Anne Bordeaux, Learned Standing Council Revenue, submits that some more time may be granted to enable her to obtain the instructions, full stop para. On the other hand, Sri, your name?
T. Hussain,
T.
my lord.
Hussain.
Yes.
Sri T. Hussain, Learned Counsel for the petitioner submits that there is another writ petition which
Seven.
with a similar cause of action,
Similar.
being WPC
7182
7182 of
public 2023, my lord.
7182 oblique 2023 full stop para.
Minuta.
List after 2 weeks along with WPC so and so. By which time Ms. Borderline may obtain the instructions oblique file affidavit in opposition.
Dimly obliged. My lord, interim order, my lord, yes.
The interim order passed.
Because
Okay. And the interim order passed earlier to continue till the next date of listing. Taragut Lihiba, as agreed to by the parties, list on
first, second,
April.
After breaking.
First,
after 2 weeks,
we'll have in 3rd of April.
okay.
Dimly obliged.
Right. After this review petition, my lord, my lord, kindly acknowledge me for today, my next week matter may be picked and maybe pass any order, my lord.
What is
Only
the order? What is the
order is, my lord?
The petitioner was required to be inducted into service.
Yes,
They were
madam.
given the liberty.
You are
to
the
conduct
petitioner, writ
and-
petitioner.
and
Yes,
for
madam.
review. They have not explained the delay in filing the review petition. And they have not even, now in the review petition, they have said why they.
What was the direction to?
My lord,
Like,
they had put me out of service on medical ground. The matter went before a review medical board, the opinion of the medical board was after my rejection. First, they rejected me, then they took a specialist opinion. On that ground, Lordship had, directed that I should be reinducted into the force, and they were given the liberty to take any review medical examination.
Is-
That,
Yes, my
that
lord,
they have not
my,
followed.
my defense is that in this order, my lord, that is periodical directed to periodical medical, induct him to on subject to periodical medical board, my lord. That may be review, that may be review medical board or appeal medical. A periodic medical board is for those persons who are in service, my lord. That is only my prayer for review, my lord. That is only my prayer.
Tell us when will it be convenient?
My lord, on 19 or 20, my next week, my lord.
But we here, this bench was not available for a long time. These review matters are pending since long.
Yes, my lord. Then when?
Heard Miss A. Gayan, learned counsel for the applicant, whereas Sri R. Mazumdar, learned counsel appears for the opposite party, writ petitioner, full stop para. Sri Gayan prays for a short adjournment, full stop para, as agreed to by the parties. List on
19 or 21, my lord.
19.
Contempt case along with,
Content.
I don't know, 41, but connected. contempt.
41. List along with 41 too.
Pleasure. Which are state, my lord.
Huh? Yes.
Your lordship should find the order method of which we seek a review. Lordship will find at page 132 of my review petition.
132,
my lord, at para 5. This is one of the grounds, my lord, I'm. Page 132, para 5 is lordship's orders, my lord, one of the. It is an admitted case that none of the petitioners had acquired trade DLA qualification within the upper age prescribed for various categories. However, it is also a fact that even before the advertisement dated 11/3/2018 was issued, all the petitioners were possessing TET DLA qualification. It appears that due to non-fulfillment of the criteria, the candidature of the petitioners were rejected. Lordship will find that it was held that 11/3/2018, they all had the qualification.
Correct.
Now, my lord, the
11/3.
my lord,
11/3.
11/3/2018, my lord.
Yes.
Now, my lord, we'll have page 76, my lord, which is a part of the repetition.
Yes.
Lordship would find that para number 6,
Yes.
The petitioner basis state that immediately after having a opportunity, she got admitted to the DLED program initiated by the National Institute of Open Schooling through online portal in the year 17 and acquired diploma in the year 2019. So as on 2018, my lord, she did not have the diploma in elementary education, and after the lordship will have page 81, paragraph 13.
Page 81.
Page 81, paragraph 13. The last line lordship will find she qualified TET in 2009.
2000 and?
Page 81, para 13, second last line. Eligibility test in the month of November 2019 and declared the result in the month of 2019. Petitioner
December.
appeared and passed the test opening qualifying marks. So, admitted case of the petitioner that the qualifications were acquired in the year 2019, whereas the advertisement was of the year 2008. So, perhaps that recording would need a review for the petition. The finding at page 132. 53
You
repetitions.
got earlier orders of this nature?
My daughter, yes. That right now, I'll just get.
Sri R. Mazumdar, not on record. Learned counsel for the applicant, who by means of this application has sought for review of a judgment dated 21/12/2021 passed by this court in a bunch of writ petition, including WPC
4182.
4182 of 2020.
2020.
2020, full stop. By drawing the attention of this court to paragraph 5 of the judgment, comma, it is submitted that this court had come to a finding that before the advertisement dated 11/3/2018, comma, all the petitioners were possessing TET oblique DL ed qualification. Full stop. Para, the learned counsel submits that the aforesaid observation had crept in inadvertently, as a number of petitions were considered and disposed of by the common order. Full stop. He submits that in the instant case, comma, the qualification of TET was obtained much after the last date of the advertisement, and therefore the directions given in the aforesaid order would not be applicable to the opposite party in this case. Full stop. Para. Let notice be issued, returnable by 4 weeks. Let steps be taken for service of notice upon the
primary
respondents.
There are two respondents. The primary respondent will take, the other will
Upon the-
take a standing out.
Yes. Where? Upon
Page 2, my lord.
Upon the respond number 1 by registered post to HAD. Let an extra copy of the writ petition be served on SCGC, anyone CGC? Upon Sri H. Gupta, learned CGC, who accepts notice on behalf of the respond number 2. Full stop. List along with?
The WPC numbers I'll give.
Not WPC, review petition.
Review petition, sir. I'll
Please give.
Next, review number. Item 43, Lordship put the same, my lord, paragraph of the judgment, my lord, where it was held that they were all. Lordship will find at page 83, para 2.
আবার একটু লিখে দাও, এটা সিমিলার হবে।
Will the para remain same?
Yes.
They make contradictory statements, my lord, at page 83, Lordship will find, I'm sorry, my lord, not page 83, page 84, Lordship will find that however, before the petitioners could take steps to apply in pursuance of the aforesaid advertisement, process was stayed. That is what they state there. They wanted to pursue it. Then Lordship will find at page 86. Fourth line from the top.
86
of the review petition.
Yes, please.
Fourth line from the top. Advertisement, it starts with the word. That is 11/3/2018. The petitioners were pursuing their DLED for the session 2017-19. So on 11/3/18, my lord, they were not having the qualifications. They were still pursuing.
আরম্ভকে নিয়ে কি হবো? For judgment, including WBC? Including WBC or
This is WBC 2771 of 2021.
including WBC এইটোৱে বেলেগ হ'ব। পিছৰ নেক্সট পাৰ্টটো কি আছিল? Of? Of 5 এইটো ফুল তাৰপিছত? Eleven 2018 তাৰপিছত কি লিখিব? As a number of petitions we can. Very common judgment and order of. That's what he in this connection at I hit Agot in this connection. He refers to the averments made in paragraph in the earlier case.
In the earlier case,
Paragraph, what was the paragraph, the date?
The earlier case, it is the paragraph number 13.
Paragraph 13 of the writ petition.
In the earlier case. In this case,
And it refers to paragraph
4. I'm sorry, not paragraph 4, paragraph 8.
Paragraph 8. It would be 8. বাকি সব একে, হ্যাঁ? আর কোন কোন অর্ডার হেরি অবস্থায় না অর্ডার অবস্থায় দিয়েছিল সাইরাস সাইরাস এটা petitioner আছিল, এটা বহুত petitioner আছে। Sorry, writ petitioner বহুত আছে। এটা না, এটা কোনো one না এটা। That steps be taken for service of notice upon the opposite party numbers 129 by registered post to CD. Steps within 3 days. আগোটা ঠিক মনে করেছিল? এটা তো হবো এতেও। আর স্টেপসের ওঠা কি হয়েছিল? আগোটা? হ্যাঁ, কেউ রকম। No, এটা তো হেৰি আছিলে।
On the first one, my lord, there is one petitioner. I'll take steps by registered
Registered
AD.
post কিমান কৈছিল? Returnable? Steps within? লাগিব first-ত। কি কৈছে first-ত কি issue notice? তাৰপিছত returnable by 4 weeks? Steps within 2 days. 2 days লিখি। তাৰপিছত be served upon the respondent Gupta, Council for respondent number 2. আচ্ছা আৰু ইয়াতে ছেকেণ্ডটো লিষ্ট এক্সট্ৰা কপি নাহে আৰু ইউনিয়ন অফ ইণ্ডিয়া নাই লিষ্ট along with give the number সেইটো সোমাই দিব Okay, next.
Last order, the government to advocate order dated 18/12/2023 vacancy.
Yes, government.
Lordship, when I noticed our name not been reflected, so that's why my lord have
Item number?
44.
Mr. M. Chutia was there. We have contacted, my learned friend has contacted him. He said he does.
Otherwise, my lord, that protected this, my lord, that appreciate there, then. Have not been reflected.
We'll have it on Tuesday for disposal.
Got
This is going on for some quite some
Yes.
time.
Tuesday,
Tues-
my lord, some appropriate, the government. to take
Yes, sir,
the-
we'll direct list, reflecting of GS in the cause list.
Yeah.
Heart, three,
The last order, your lordship was directed to.
yes, Heart three BD Das.
Reflect me.
Oh, Kushil,
Okay.
Heard three BD Das Learned Senior Counsel for the applicant. Also heard three MU Mahmood Learned Counsel for the opposite party writ petitioner. First of para. When the matter was taken up on the last occasion, that is 22/2/2024, comma. This court has noticed that the state was not represented as name of GSM was not reflected in the cause list, full stop. Accordingly, a direction was given to the registry to reflect the name of Sri M. Chetia, learned GSM, full stop para. The cause list, however, does not reflect the name of GSM even today. Full stop. List para. um, And then it appears that the orders of this court are not placed before the appropriate authority for the follow-up action, which requires follow-up action full stop. This aspect may be brought to the notice of the Registrar General full stop para. Be that as it may, list this case on, tell us. Which date? Tuesday.
Tuesday. 9.
On
19th.
on 19th March 2024 by reflecting GSM in the cause list.
Forty-five, my lord, it is land acquisition case, my lord. The railway has not deposited the, my lord, the amount compensation.
My lord, in the contempt case, my lord, there is an order passed to list this matter along with the review petition. So we have preferred a review petition, my lord. Before the learned single judge, my lord, the petitioners, they have approached, my lord, claiming for compensation. My lord, in fact, the land was not acquired, my lord. The fact of the case that that, my lord, the lease charges were paid, my lord. Railway has acquired certain portion of land for construction of service road, and lease charges were paid. So the landowners, my lord. There was no permanent acquisition, my lord. There was no notice under the Land Acquisition Act. Lease charges were paid to, my lord, initially around 53 landowners, my lord. Then this writ petition was preferred, my lord, after 10 years, my lord, the order under review, my lord. My lord, there the writ petition was preferred by another set of landowners, my lord. They also wanted to claim the compensation. Now, my lord, the order is at page 21, my lord. It is the type order, my lord, page 21.
Order of whom?
The order of the learned chief judge, my lord, which is against which we have preferred review, my lord, page 21.
Okay. Yes.
Here, my lord, paragraph 2, my lord, if I may read, my lord, without going into details, it would be sufficient to take note that the claim of the petitioner is that the land which is under their occupation was taken over by the railway authorities for the purpose of construction of certain service roads for the railway line, but no compensation into thereof have been paid. After detailed deliberation, Mr. Tinker Das, Executive Engineer, Construction Pastikat, NFLW, upon verification of the records, made statement before the court that the land of the petitioner was utilized by the railway authorities for the purpose of the service road, but no compensation thereof have been paid. Accordingly, Mr. Tinker Das make a statement that the railway authorities will give appropriate consideration to the matter and ensure that whatever compensation the petitioners are entitled under the law to be paid in lieu of the land that has been taken would be paid. My lord, in paragraph 4, my lord, thereafter, a stand is taken by the railway authorities that the land of the petitioner is a government land. In this respect, we take note of a communication dated 26/2 from Deputy Commissioner Demaji to the Deputy Chief Engineer Bokipal Project Tilapatta Demaji, providing that certain land has been used for construction of the service road from Kulazan to Karinghat Bokipal project, but in respect thereof, compensation has been paid to 53 affected landowners, but another 148 landowners have been excluded from the benefit of payment of such compensation. Accordingly, the Deputy Commissioner estimated an amount of rupees 993,620 for annual patta lands that have been utilized by the railway authorities, and another amount 2 crores 36,79,300 in respect of 219 vigas 4 kattas 15 liters, which apparently appears to be government land under occupation of the respective land. Lord, our contention is that, my lord, we are ready to pay compensation in the form of lease charges in respect of those landowners who are having patta, but in respect of the government land, my lord, the compensation cannot be paid. My lord, thereafter, my lord, in paragraph 5.
Where is the direction?
My lord, paragraph.
Funny.
Lord, may I read paragraph 5 before I go to direction, my lord? Paragraph 5.
Yes, please.
Accordingly, a request was made that the aforesaid amount be released at the earliest. The railway authorities, in response thereof, by their communication dated 29/2/16 from Yashpal Singh, Deputy Chief Engineer Construction 1 NFLway, had informed that the Deputy Commissioner that the land was taken on temporary lease for service road from Kulazan to Bokivil, but in respect of such temporary leasing, the railway authorities can give compensation either to individual patta holders or to the government for government land. My lord, here the confusion has arisen, my lord, that the consent which was given by the railway official, my lord, that we are saying it was contrary to the stand taken in the affidavit, my lord. My lord, at page 151, I will just read, my lord, one small paragraph before I continue. My lord, page 155. For a moment, that is the affidavit, my lord, filed before the learned single judge. My lord, paragraph 15.
Affidavit by whom?
By the railway. Paragraph 15, page 155, my lord, at the bottom.
Yes.
That with regard to the statement made in paragraph 17 of the petition, it is replied that railway had temporarily took land on lease basis on execution of deed of agreement with landowner for government public patta land, making payment of lease. No compensation is payable for government land to the individual occupant of the land. So, my lord, this is the difficulty which we are facing, my lord. Thereafter, my lord, I will continue with that the direction part, my lord, page 22, which I was reading, my lord, paragraph 5. Lord,
Yes.
if it is the stand of the railway authorities, from the middle I am reading, my lord, paragraph 5 where I've discontinued. Sixth line from the bottom, my lord, paragraph 5. If it is the stand of the railway,
Yes.
railways authorities that in respect of the government land and the occupation of the respective landowners, the railway authority will pay compensation only to the government and not to the landowners, be it so, but let the appropriate compensation be deposited to the government, that is to the deputy commissioner. My lord, initially we preferred a writ appeal, my lord. Before the appellate court, my lord, the court directed since the consent, it's a consent order, my lord, the court was of the view that we better prefer a review petition. Accordingly, my lord, after we withdrew the writ appeal and filed this, my lord, review petition. And my lord, the direction.
Where is that writ appeal withdrawal order?
Order, my lord, is that. Is 197.
Liberty was granted to you.
Yes. My lord, this is our basic, my lord, difficulty, my lord. I am also, my lord, relying on a decision to support my contention that, my lord, for government land, my lord, no compensation can be, should be paid, my lord. 2010, 10 SCC 656, my lord. Paragraph 17 and 18. Paragraph 17 and 18, my lord.
Yes, please. Even otherwise.
Even otherwise, if the land already stands acquired by the government and if the same stands vested in the government, there is no question of acquisition of such land by issuing a second notification, for the government cannot acquire its own land. The same is now settled by various decisions of this court in a catena of cases. In state of Orissa versus Vrindavan Sharma, this court has held that the Land Acquisition Act does not contemplate or provide for the acquisition of any interest belonging to the government in the land on acquisition. This position was reiterated in a subsequent decision of this court in Meherushi Dalal versus Union of India in paragraph 15 and 16 of the said judgment. This court held that the High Court clearly erred in setting aside the order of the special land acquisition officer, declining a reference since it is
How do you explain your delay in filing the review?
My lord, we filed appeal initially, my lord. Appeal was
When did
filed
you
in-
file the appeal?
My lord,
When did you file the appeal? We have seen the
appeal was
order.
filed in time, my lord.
It was also a time bar. They filed a continuation petition that was
Allowed.
Then they.
Well, we have explained, my lord, we preferred appeal along with the condition of delay. My lord, the delay, my lord, we were writing to the authority. In contempt, my lord, we have already filed our detailed affidavit. The delay has occurred because, my lord, the railway has been corresponding with the office of the deputy commissioner continuously.
No,
my lord.
where is the explanation in this review? Review also, there is a question of latches will come in.
My lord, since we have preferred appeal and the liberty was given by the appellate court to prefer review.
Liberty is only to file. Liberty is not to allow the review.
Well,
We have to consider in accordance with law. You have to overcome the hurdles of law.
but the review has been preferred, the, you know, 30 High Court rules are not there. Time period is not there, my lord. That is,
Time period is
30
not there,
30
Mr.
days.
Gupta, you're a citizen council, we are
My lord.
talking about latches, not of limitation. Not
My lord.
delay, of latches. What is the law regarding a writ court in treating a review petition which is barred by time?
my lord,
Well,
since
a
we are
civil
bona
court.
fide pursuing the writ appeal, and the reasons, my lord, why we prefer writ appeal delay, my lord,
When did you file the writ appeal?
my lord.
What is the order, what is the date of the order first?
Date of the order, my page 197, my lord. 12/1/2014.
Hmm?
12/1/2024.
No, no.
12/1/2024.
No, no, no,
The order.
the order which you are seeking review,
Well, that is, my lord, that is 9/9/22, my lord.
9/9/22. When did you file
We
the
filed the
appeal?
appeal, my lord, on 14/11/23.
14/11/2023. That was itself time barred.
Along with the condemnation, we filed, my lord. And in fact, my lord, in the contempt petition, we have filed our affidavit in opposition. It's not that, my lord, detailed affidavit in opposition. There we have annexed all the communications after the passing of the order, my lord. We have been writing to the deputy commissioner asking for the ownership details, my lord, of the Patta land. But the
Okay, we'll
ownership,
consider today, we may not have time, but
well,
you have to come prepared with the delay.
My lord,
round.
my lord, if the stand of value is, my lord, then, my lord, the deputy commissioner also filed affidavit, my lord. My lord, it is not the railway, my lord, whether the compensation is to be payable or not. My lord, earlier, their stand was, my lord, that for about 4 or 5, my lord, landowners, they have entered into a lease agreement. So lease agreement, my lord, with private persons, my lord, how they can, my lord, take the land?
that is on
On
the
the
basis
basis of,
that was
that
there.
was their stand in the writ petition, my lord. Now, my lord, assuming that it is
The
a,
order was an inter partes order, isn't it?
my lord,
The order
yes,
passed
it
in
was
20
contested, very contested order, my lord. But writ petition was filed in the year 2017, my lord. It was disposed in the year 2022, my lord, after 5 years. And my lord, their stand is that since from some of the landowners, my lord, they have entered into a lease agreement, so they are ready to make the payment according to their lease agreement, my lord. So that is still, my lord, how it can be, my lord. The land has been taken, my lord. Ultimately, my lord, whether it is a patta land or, my lord, annual patta land, my lord, Miyadi patta land, my lord, once the land is acquired by the government, my lord, it is the state government, my lord. And so far the compensation is concerned, my lord, it is the deputy commissioner.
Has it been acquired?
Yes, my lord.
No, my lord, there was no
Yeah, my lord, my lord,
That is
my lord,
the confusion. my lord.
the deputy commissioner also filed affidavit in contempt notice, my lord.
Okay, we'll say. it.
There is
You
no
tell us a date. Today it will not be possible today.
My lord, a short date because, my lord,
Tell us, Mr. Gupta, when
My lord,
paucity of time did not allow the matter to be taken up.
today,
today, 13.
Full stop para, as agreed to by the learned counsel for the parties. List on.
My lord, can
first
it be,
week of April.
my lord, can it be on, my lord, since 2004, my lord, they have not paid any payment. They have not-
Tell us the date.
My lord, 21st of this month.
Next week, I think we are already, we try to have it on 4th of April.
4th
April. Thursday.
My lord.
Thursday we'll have a hearing.
Or my lord, second.
Second rakhi se naam hai, second ko aisa nahi. 2nd April, no problem. 2nd April. Rest of the matters will give date. Is there any matter where interim order is still today? Otherwise, court master will give dates.
Thank you.